for holding this hearing and working with Senator Lee and myself. This is clearly a bipartisan endeavor. We have interest from both sides of the aisle. And I think you all know, as Senator Durbin mentioned, that competition policy is very important to me. I believe in capitalism, and to have a strong capitalist system, you have to have competition. You can't have too much consolidation, something that unfortunately for this country, as a ode to Taylor Swift, I will say, we know all too well. In over 75% of our industries, ranging from agriculture to pharmaceuticals to tech to live events, a smaller number of large companies now control more of the business than they did 20 years ago. At the end of last year, I worked with members of this committee and our bipartisan partners. Particularly, I want to mention Senator Grassley, and over in the House, Nagu, Cicilline, and Buck, to finally update our merger fee statute that had not been updated for decades. That is going to bring in $100 million a year for our enforcement agencies, from the Justice Department to the FTC. It is really important. We also passed a key bill that Senator Lee has been advocating for on venue with the tech companies, and allowing the state AGs to keep the cases in the states where they bring them. I think you're going to see more cases and more investigations coming out of the Justice Department. Watch for it, and I think that's going to be very important. But why am I here today and have taken this on? I love music. So I grew up in the suburbs in high school. I remember loading into Johnny Royer's van and with my friends and going off to see Led Zeppelin and the Cars and Aerosmith. And now I don't think it's very easy for high school kids to make their money at Baker Square Pie Shop on the weekends and buy tickets to these major concerts. My state also has made more than its share of contributions to music, from Prince to Bob Dylan to Lizzo, and in fact, First Avenue, the iconic event space where Prince got his start and was made famous in the movie Purple Rain, is a point of pride for the people in our state, and it's one of the reasons Senator Cornyn and I worked so hard to pass the Save Our Stages bill, which was the biggest investment in the arts in the history of America. So whether it's for fans, performers, promoters, or venue operators, we need to make sure we have competition to bring prices down and bring innovation in and stop the fiascos. Today, Live Nation doesn't just dominate the ticketing. It's about 70% of the big concert market, but also they own many of the major venues. And for the venues that they don't own, they tend to lock in on 3, 5, 7-year agreements, which means that the competitors that are out there aren't able to even compete when it comes to the ticketing. Finally, they dominate the promoting. So we have talked to many venues, some of which aren't willing to come forward, unlike one of them that is here today, but that say even if they're not out there threatening them, they're afraid to go to someone else because then they're not going to get the acts that they want. This is all a definition of monopoly, because Live Nation is so powerful that it doesn't even need to exert pressure. It doesn't need to threaten, because people just fall in line. They continue to expand. Ticketmaster has gotten into the ticket resale game so they can charge fees when the ticket is first sold, and then additional fees on the resale of the same ticket. The live event experience has become increasingly out of reach for so many fans. One GAO study found that 27% of the ticket price was the fees. Recent study found that for some tickets, it's as high as 75% of face value. And we also know it affects service. As millions of Taylor Swift fans found out last fall, there are few consequences for failing to deliver the service. But Taylor Swift, I think it's important for our colleagues and all to note, is just one example. Whether it's Bruce Springsteen or BTS or Bad Bunny or in the past Pearl Jam or the Pixies, fans, artists, and venues are facing real issues with Live Nations. I'm hopeful this can be a constructive hearing. Purposes of hearing: 1, so the public can find out what's happening. Sometimes that on its own gets changed. Secondly, Investigations are reportedly going on. We haven't had that confirmed out of the Justice Department. This is helpful for them. And the third reason is that our colleagues on a bipartisan basis can work together on legislation. Senator Blumenthal's been involved in this issue for many years, and we can do something, not just to strengthen our antitrust laws, which we must do generally, but also specifically in the ticketing industry when it comes to transparency and resale and the like. Restoring competition to our markets is about making sure that fans get fair prices and better service. Concert goers today should be able to have those same experiences I had when I was in high school, when it didn't cost very much to just be able to go see a band and remember it forever. Thank you.
Thank you, Senator Klobuchar.
Thank you very much. I'll start with you, Ms. Bradish. As a former antitrust attorney who studied these markets, Mr. Berchtold, we've heard serious concerns from artists, promoters, venues that Live Nation's dominance in the concert tour promotion can pressure venues to use Ticketmaster's primary ticketing service exclusively. How else would you explain?
By the way, if you look at the difference between the Target Center in Minneapolis and the Xcel Energy Center in St. Paul, the Target Center is ticketed by Access. The Xcel Energy Center is ticketed by Ticketmaster. Look at the number of shows that play Xcel, and you'll see they far exceed the number of shows that play Target. And when you look at and break it down a little farther, you'll see that most of the shows that play Xcel are Live Nation shows, and they bring very few to the access-controlled venue, the Target Center.
Okay, thanks for that local reference. Mr. Berchtold, one way that Live Nation eliminates competitive pressures by locking venues into multi-year contracts, whether they're 3 years, 5 years, 7 years. If you've tied up 80% of major concert venues with multi-year contracts, where is there room for one of your competitors to get in the door?
Yes, Senator. First, I would note that the 80% reference, I believe, is from a 2008 Department of Justice study, and we believe that our market share is substantially lower than that.
How much lower?
We would, variety of ways of estimating the market share in the industry, depending on what you include. We believe our market share would be somewhere between the 50 and 60% range.
Keep going.
Yes, I will note a very specific indication of the high level of competitiveness is first that with almost every contract renewal we have over the past decade, more of the money gets accrued to the venues as opposed to the primary ticketing provider, which would be one indicator of a very competitive marketplace. Secondly, I would note the success that SeatGeek had between 2018 and 2022, adding roughly 15% of the NFL and the NBA teams as primary ticketing clients, showed the level of movement of these clients.
Okay, Ms. Bradish.
So, of course, it makes it much harder for particularly a newer entrant to get into the market if everybody is already tied up.
And Mr. Grotzinger, do you think that, to go to another topic, that Live Nation's concert promotion business, the fact that they're combined, has made it harder for you to compete for primary ticketing with Ticketmaster?
Yeah, absolutely, it has. Typically, we'll go.
Mr. Lawrence, what was the amount you said, the percentage of your tickets, some of the highest ones you've had recently, that were fees?
Typically with Ticketmaster, we'll see a 40%-ish or closer to 50% fee added on top. We have seen really outlandish numbers, like we had a show last spring where there was an 82% fee on top of the base price. And again, we have no say or we don't even know what it's going to be until it goes on sale.
Mr. Berchtold, you heard Mr. Lawrence. With Ticketmaster's market power, which we all know exists, we'd be kidding ourselves if we said it didn't exist. Why haven't you done more to reduce fees?
As I noted in my comments, Senator, the fees are set by the venues. The Live Nation venues have fees that are consistent with the other venues in the marketplace and cover the cost of the operation of those venues.
Mr. Lawrence wants to reply.
We definitely ask venues before almost every show, what's the ticket fee going to be? Both venues that Live Nation owns and ones that they just operate. And they always certainly don't take responsibility for the fees. So I don't know who is doing the fees, but we ask that question to the venues and they say, not only do we not choose what it is, we don't even know what it is. We can't even tell you what it's going to be. So I don't know where the answer lies, but no one's
Okay.
taking responsibility.
Last word, Ms. Bradish. Transparency would be helpful to know what the fees are. Is that right?
Yes, absolutely.
Okay.
The market can't work well without transparency.
That's clearly there isn't transparency when no one knows who sets the fees.
Yes.
Okay, with that, Senator Cornyn.
Thank you very much. Appreciate all the witnesses.
Good questions about the market percentage of you, Mr. Michelson, and you brought them up. And because I think people need to hear these numbers. So according to your testimony, 87% of Billboard's top 40 tours in 2022 were performed at venues ticketed by Ticketmaster. Is that right?
That is correct.
And Mr.
87%. Yes, correct.
And you disagree with that, Mr. Brookto?
I don't know the numbers that he's talking about. I haven't done the analysis, so I couldn't comment.
Okay, well, we'll do that in writing, but it seems to me like that's a lot. Okay, and then secondly, another thing that he brought up, you brought up, Mr. Michelson, in answer to Senator Cruz. Today, 87% of NBA teams, 87.5% of NHL teams, and 93% of NFL teams, I assume including the Vikings, have exclusive ticketing agreements with Ticketmaster. Is that right?
That is correct, and the teams are broken down in my testimony that I provided.
Okay. Dispute?
That seems inconsistent, Senator, with the information that I indicated about SeatGeek taking between 2018 and 2022, 15% of the NFL and the NBA market.
Okay, well,
I would say that I do acknowledge we absolutely have the leading share
Okay.
in those because there's no mystery. We have the best product. And we have a product that is particularly suited
Okay.
to the very complex requirements.
We were just doing facts here, so, but I understand your answer. Mr. Grossinger, do you want to reply to that?
Yeah, I wholeheartedly disagree with the assertion around product. I think we don't know who has the best product because there's not competition. There's only one real choice that a venue can make.
Okay, and then in 2020, and the DOJ confirmed that Ticketmaster has been the, quote, largest primary ticketing service provider for major concert venues in the United States for at least 3 decades. I don't think we doubt that. Anyone? Okay. Next, Live Nation revenue grew from $5 billion to over $11.5 billion from 2010 to 2019. Is that correct, Mr. Brookholt?
I don't have the exact numbers, but that sounds right.
Okay. Then we have, I'm just going to quote from a New York Times article, 2018, that said this, and if it's wrong, you tell me, and maybe it's changed a bit because it's 2018. Ticket prices are at record highs, service fees are far from reduced, and Ticketmaster, part of the Live Nation empire, still tickets 80 of the top 100 arenas in the country. No other company has more than a handful. No competitor has risen to challenge its preeminence.
As I indicated in my comments, I believe you said that was 2018. Between 2018 and 2022, SeatGeek in particular has been very effective in winning major NFL and NBA clients.
Okay, but do you know, Mr. Grossinger, if we're like 5 off for the number of arenas or what we
In
are
small
here?
percentages. My data, which our team pulled, was that Ticketmaster is the primary ticketing provider for more than 80% of the NBA, NHL, and NFL teams. I would also note
More than, say it again,
more than 80%.
80%, yeah.
And that was around the same percentage back in 2009 when we were first looking at this.
Yeah, I just want to dispel this notion, Ms. Bradish, that this is not a monopoly. And then we can go from there about solutions. So let's talk about that. Ms. Bradish, you talked about the need to update our antitrust laws. Senator Lee and I have had numerous hearings. We have made headway, as I noted, at the end of the year to focus to help our antitrust enforcers so they're not taking on the biggest companies the world has ever known with duct tape and Band-Aids when we know there are a number of people that work at these agencies, or in some cases less than it was during the Nixon administration, and yet these companies have grown bigger and bigger. So I appreciate the support of the United States Senate on this front, Democrats and Republicans. Now we have to go to the next step, which is, albeit harder. We have some specific things we're all working on tech, when it comes to issues like ticket prices. But the issue here is that we've seen a narrowing of our antitrust laws, and that's why I think for both discriminatory conduct and mergers, we need to step back a bit, as a number of us have on this committee, and look at some changes. They don't have to be exactly the changes each person wants, but could you talk about the importance of making it easier to enforce these antitrust laws when we have seen 75% of the industries in our nation, from cat food to caskets, see more consolidation?
Yeah, I mean, in particular with respect to vertical mergers and monopolization Section 2 cases, case law has narrowed and narrowed and narrowed the window for the enforcers to go after this kind of conduct. So anything that will open that window, that will give an opportunity for the enforcers to actually get at this conduct and this kind of merger activity, is going to be what we need to restore competition.
Okay. Anyone want to add to that? Okay. Some of today's witnesses we know have raised, and we really appreciate all of you, concerns about ticketing, especially you, Mr. Lawrence, with some very practical things. It would be great if some of these kind of smaller things that are difficult for you to deal with just got resolved after this hearing. We love that. It shows we did something for the day for a change. So that's great, but I think we all know, as Ms. Bradish has been pointing out, and as Mr. Michelson and Mr. Grosinger and Mr. Nuzzo has been pointed out, these things are sometimes bigger than that. And let's get what we can right now, but there's bigger things. So one of the things we've heard complaints about is so-called drip pricing, when the consumer doesn't see the full price of the ticket, including fees up front, and has to wait until near the end of the transaction process to get the final price. This is what was just pointed out, right, Mr. Nuzzo?
Yes, correct.
Okay, very good. Should Congress mandate all-in pricing on ticketing platforms so that the full ticket price is disclosed up front?
I would stipulate that there is likely an interstate commerce reason for Congress to act in this capacity. I live in North Florida. There are a lot of people from South Georgia that come to Tallahassee occasionally when the Florida State Seminoles are having a winning season. And so from the extent and the nexus of interstate commerce, I would stipulate there's probably a window for Congress to act, even though I would also like to state on most issues I am a states person.
I just guessed it, but okay. Anything anyone wants to add to that? I noticed you were consulting with, I would like to say your lawyer, but it's your bandmate, Mr. Lawrence, in answer to this question. It was very, very impressive. All right, go ahead.
I just wanted to say, I think while the spirit of the all-in pricing thing is a great idea, a concern that I have is if artists continue to have no say in the on-top portion of the fees, then like while, as we talked about, I do have a say in setting the base ticket price, all of a sudden if I set a ticket price of $30, but then they're just seeing an all-in fee of $50, at least in the current system, fans know which is the base ticket price and which is the fee. So even if the drip pricing were eliminated, it would still be great.
So you want to do something up front to...
If there was something on that first screen that still said, these are the added Ticketmaster fees, so that the fans know...
That was my second question. Like, you should be a senator, I think, here. So what you're saying is you want to differentiate on the fees, and then you also want to deal with this.
But what I really want is for artists to have a say in those fees and for them to be lower. But under the current system where we have absolutely no say or transparency in the fees, I wouldn't want to have to take any responsibility of those to our fans.
Okay. We have anyone on this? Okay. We also have heard about sellers offering to sell tickets they don't even have. That's speculative ticket sales when they don't have it. Is that something that Congress should prohibit? Mr. Michelson?
Definitely. I mean, you go online and on any high demand show, and they're selling tickets that they do not have. Absolutely, and Mr. Bergtold could certainly opine about that, but that needs to be banned somehow. I don't know whether it's Congress or by state, but something needs to be done. It's deceptive and just not right.
Okay. I know you, Ms. Bradish, talked about this idea of spinning off companies. We've all seen that as a remedy that would most likely be coming from the Justice Department. So all we can do here is put forward the evidence, and these are sworn testimonies back and forth under law so that the Justice Department can look at this discussion. But clearly, this is something that could be looked at, because I think we can legislate on some of these things about pricing. But if you truly have a situation where you have a monopoly on this three corners of this triangle, right, which is this combo of the ticketing and the promotions, and then the arenas, or not all arenas are owned, the long contracts, long-term contracts on the arenas. That is also an issue that that creates this problem for us, where the customers are basically trapped in the middle. So anything anyone wants to comment about that and how that would aid you in competing, Mr. Grosinger? Oh, Mr. Michelson.
Thank you. Again, when I look back at history, which always guides us, I look back at the Paramount case, U.S. versus Paramount in the late 40s, where the movie studios contracted and controlled the actors. They made the films, they had the distributor, and they had the movie theaters that those played in. The government broke that up, and then it became fairer for everybody else to compete. So I think that's a solution you need to look at. I think another solution might be maybe no exclusive ticketing contracts at buildings. In Europe, in the UK, they don't have exclusive
That's what
ticketing
my
contracts.
last question was going to be, and we'll
Sorry.
count that answer. No, it's interesting. So they don't have that
Right.
in Europe. Okay. All
Another-
right. Anything more?
Oh, sorry, I was just going to mention, another difference between the Europe and the US market is that for Europe soccer teams, for EPL teams, they typically don't have concerts. So they're not worried about this whole concert threat that we've been talking about. And as a result, you see a markedly different market outcome, where those venues actually make the ticketing decision based on the merits of the product, what's actually best for their fans and best for their business. And we've been talking about the 80% or so market share that Ticketmaster has here in the US among major sports teams. That's only 20% of EPL teams, whereas SeatGeek's fortunate, due to a stronger product, to have about 10 of the 20 EPL teams there.
Okay. Senator Lee is deferring to Senator Blackburn. Thank you,
Thank you, Madam Chairman. Let me just say,
Mr. Chair. So thank you so much. This has been an incredible hearing. And as you know, I'm involved in this issue. I thank Senator Blumenthal and for his work, and Senator Blackburn, so many others. So I would agree, we need rules of the road. We need rules of the road for everything from the what we're talking about here for kids to privacy to competition, because there's just no rules of the road. As Senator Kennedy has expressed, we have tried in many ways and passed a number of bills in this committee. I believe one of these days they're going to start to pass because the social media companies have stopped everything in their tracks that we have tried to do. And I think it is important, I guess I would start with that, that they are companies and they are media corporations, basically. And I try to explain to people that if you put something online or put it on one person does it, that's bad, that's one thing. But or if you yell fire in a crowded theater, okay, that's on you. But if the multiplex were to take that yelling fire and put it in all their theaters with an intercom so everyone could hear it, that's a whole nother thing. And that's a problem that hasn't been solved when it comes to these companies. They are profiting off the repeating of this information and the spreading of this information. So, Mr. Golan, I just ask you this. In addition to setting the rules of the road that we want to do, when we talk about auto companies and all these other areas, at some point, people have been able to sue them for problems. And right now, these companies are completely immune. Do you want to get at that and talk about your views on that?
Yeah, I think that's a huge piece of the equation is the ability of parents and young people themselves to hold these companies accountable. Kristen talked about her lawsuit being thrown out. We work with Tawana Anderson, whose 10-year-old daughter died after attempting the viral choking challenge, which TikTok put into her For You feed. It's not something she was searching for. TikTok's decided that this was the piece of content that would be most appealing to her at that time. And their case was thrown out of court for Section 230 reasons as well.
Right.
So,
okay, I just want to make that clear. The rules are good, but I'm telling you, if you just pretend that they are a loftier than any other company class that can't be sued for anything, we're never going to get a lot of these things done. So let's be honest about that. The Respect for Child Survivors Act. So this is something Senator Cornyn and I passed. Mr. Prinstein, do you agree that it's important for mental health professionals to be involved in interviews of child survivors? This is this idea that whatever the crime, I was a prosecutor for quite a while, sexual abuse, whatever, it's important to have a coordinated effort when it comes to interviewing kids.
Yes, absolutely. There's a clear psychological science around how to do that in safe and appropriate ways.
Thank you. The issue of eating disorders, I'll go back to you, Mr. Golan. Studies have found that the eating disorders have the highest mortality rate of any mental illness. I think that surprises people. I led the Anna Weston Act, and last year, of course, thanks to Senator Blumenthal, we heard, and Senator Blackburn, from Frances Haugen, the Facebook whistleblower, about Instagram's own internal research on eating disorders. You talk about that connection between the internet, eating disorders. Do you want to quickly comment on that connection and why that should be part of our focus here?
yeah, so what happens is when girls or anyone really expresses any interest in dieting or dissatisfaction with their body, they get barraged by content recommendations for pro-eating disorder content. And so, because that's what's going to keep them engaged. So we need to create a duty of care that these platforms have a duty to prevent and mitigate harmful eating disorder content and not push it on kids. I mean, I think that's one of the really important things to distinguish between queries where people might be interested in getting some information versus what is being actually pushed in their feed. And frequently, it is the worst, most harmful content that's being pushed in their feed.
Okay. Ms. Stallone, Senator Cornyn and I did a lot of work on human trafficking, as you know, passed that original bill to create incentives for safe harbor laws. Can you talk about how the internet has changed the way that human traffickers target and exploit kids?
Yes, thank you, Senator. Human trafficking and child sex trafficking in particular has certainly been fueled by online platforms and the connectivity between offenders and children. Not only does it make buyers, it makes it easier for buyers to find children who are being trafficked, but it also allows the imagery of these children to continue to circulate, and that often keeps the victims quiet and being silenced in terms of speaking up, because their images are then being transmitted online for potential buyers to locate.
Okay, last question. Mr. Pizarro, thanks for your work. I have heard heart-wrenching stories of young people who've died after taking drugs. In one case, in drugs they bought on Snapchat through messages. A child named Devin, suffering from dental pain, bought what he thought was Percocet, and it was laced with fentanyl. And this is off of Snapchat. As his mom, Bridget, said, all of the hopes and dreams we as parents had for Devin were erased in the blink of an eye, and no mom should have to bury their kid. Could you talk about whether or not the social media companies are doing enough to stop the sale of drugs to kids online?
The social media companies aren't doing anything, period. I think that's part of the problem, and that comes to drugs as well. There's no moderation. Again, they're not looking at things specifically. They're not looking, again, you can't, from a communication standpoint, but that's what they're promoting, the social media, the interaction of people. So to my opinion, is really is that we haven't seen anything and we haven't seen any help from them.
All right, thank you.
Thank you, Senator Klobuchar. Senator Hawley.
Thank you, Mr. Chairman. Thanks to all of the witnesses for being here. Ms. Bryant, I want to start with you. I want to particularly thank you for being willing to share your.
Thank you, Mr. Chairman.
Thank you, Senator Lee. Next up is Senator Klobuchar.
Thank you very much, Mr. Chairman, and thank you. I had other hearings and things going on, but I caught up on your testimony, and I just want to thank you all for being here in this important hearing, and thank the chair for calling it. One of my focuses on guns has been on domestic violence. For too long, domestic abuse was considered a family affair. And they would say what happened in a house didn't have to come into the courthouse. We all know times have changed with the passage of the domestic violence bill, the reauthorization of it many times. But we also know that when a gun is present in the home, women in abusive situations are 5 times more likely to be killed, which is why, as part of the gun safety bill on a bipartisan basis, we put in a version of the bill that I have been working on with Senator Hirono and others for years to make sure that people that are convicted of domestic abuse can't go out and buy a gun the next day. As a survivor yourself, Ms. Glenn, can you first say more about the dangerous connection between domestic violence and gun violence? And then you could add on to that just your concern about the Bruin decision and what that will mean. Go ahead.
Thank you so much for the question. The concern, of course, is that what I stated earlier, which is that victims will feel less safe because there's the idea that at minimum, when and if I felt like I could do something about it, now I can't. I cannot get the gun removed. Secondly, I would say that we are also talking about abusive persons feeling a bit more freedom to take that few seconds to pull the trigger on a gun when there's domestic violence present by them. What we're seeing is widespread confusion, widespread concern about this particular ruling and what it will mean to the future. As we all know, domestic violence victims very seldom, if at all, call law enforcement simply because of the already present danger, particularly when there is a firearm in the home. The concern is really quite marked right now, what this will mean outside of that Fifth Circuit.
Okay, and I know, Mr. Lindley, you mentioned this in your testimony. Do you want to add anything?
Thank you for the question. With domestic violence and firearms, it's a lethal cocktail. You already stated the statistics that women are 5 times more likely to be killed when there's a firearm in the home with domestic violence. With that, there's also a danger towards law enforcement and just the greater community. So we need to really look at protecting those domestic violence restraining orders in order to ensure that women or other victims are protected, and we remove those firearms from an already volatile situation.
Okay, and I know you also are expert on this. So my state has passed a number of common sense gun safety laws to prevent convicted felons, fugitives from justice, and convicted stalkers and domestic abusers from getting a gun. And we also have this very strong tradition of hunting. It is a big part of our life with legal gun owners and people who are law-abiding. But yet, we've been able to differentiate those that shouldn't have a gun, who have broken the law, and those that have not. And so could you talk about how the Bruin decision complicates efforts by state and local governments to protect public safety?
Thank you. So California has a program called the Armed Prohibited Person System, which identifies individuals who at one time legally purchased a firearm, but subsequent to that purchase became prohibited due to a mental health issue, due to the restraining order, or some type of act of violence. That has been a very successful program, identifying people who no longer have the ability to possess firearms because of an act that they've done or a mental health issue. It doesn't deal with individuals who are still law-abiding. So with those things combined, you look at Bruin, and again, I'm not an attorney, I'm looking at this from a law enforcement perspective, that could muddy the waters with who might be having their restraining orders removed because of some act going back to 1791. Things were far different in 1791 than they are today.
Okay, my very last question, Professor Rubin, in your dissent in the Bruin case, in his dissent, you didn't have a dissent, you probably were thinking one. In the dissent in the Bruin case, which was Justice Breyer was joined by Justices Kagan and Sotomayor, he asked this question. He asked, will the court's approach permit judges to reach the outcomes they prefer and then cloak those outcomes in the language of history? Based on the cases that have recently applied Bruin, how would you answer Justice Breyer's question?
History does not speak with one voice when it comes to the tradition of firearms regulation. And one of the big risks of Bruin that we are seeing right now in the way that lower courts are addressing constitutional questions after that opinion came down last June is that courts are picking and choosing different historical laws to emphasize. They're construing them differently. They're reading history at different levels of generality, and they're pointing in opposite directions about what the Constitution means. So without more clarification about how exactly to do the Bruin test, there is a real risk that opinions will, cloaked in history, will actually be subjective.
All right, well, I will ask the rest of my follow-up questions on many on the boyfriend loophole bills and laws, implications of these cases on that, but I will do that on the record because I know my colleagues are here ready to ask. So thank you.
Thanks, Senator Klobuchar. Senator Blackburn.
Thank you, Mr. Chairman. We appreciate so much that you all are here. It's an important conversation to have, and we are grateful for your testimony. You know,
Started here, we have a number of senators with us. I'll start with you, Professor Scott Morton. I was interested to see already the 2,800 lawyers and lobbyists for the companies are now claiming that one of my points was that we should cede regulation that I said we should cede regulation to Europe and to Australia and to South Korea. They're already at it. I think you know what I said, which was that we should take the lead. We in America who believe in competition should take the lead, and that we have some good examples out there, but we shouldn't let them take the lead. So I just thought for those of you tweeting that out, you might be interested to note that that was a lie. Professor Scott Morton, could you please talk about and kind of refute some of the points that Professor Francis made when it comes to the bill, and how the bill is all about capitalism and competition. And as you know, throughout history, that has been a counterweight to monopolies.
Thank you, Senator Klobuchar. I think the parade of horribles that was listed by Professor Francis really can't happen if there's a requirement to find injury to competition. Today's courts are actually really happy to find behaviors that economists would identify as harmful to competition to be fine. The problem we have is actually excessive deference to that kind of an argument. And I think, therefore, it's natural we would have some of that here despite the beefed-up language. So the notion that courts will suddenly eliminate quality products because they have to evaluate a harm to competition is, I think, misplaced. And the kind of self-preferencing that the bill is worried about can be harmful. This is known. It's not an imaginary thing, and Professor Francis has himself written that self-preferencing isn't captured by the antitrust laws, the current antitrust laws. So what kind of self-preferencing would we worry about? What kind would be harmful? The kind that harms competition. So again, we're returning to familiar economic concepts. This is all stuff that we know from the literature. And the fact that new words are being used in this legislation is exactly to ensure that we get a new outcome. We can't use the same terminology and imagine that courts won't understand it the way they always have. So to get a different outcome, we have to use a new word and say, look, we're worried about harm to competition. In terms of innovation, I think, as I said in my opening remarks, the entrenched monopolists that we have right now should not be relied on to generate innovation. That's not what a monopolist does. It's safe. It doesn't have to run fast to innovate. Where we're seeing quite a lot of innovation is actually on these platforms now. So the apps themselves competing with each other and trying to innovate and indeed someday replace the platform.
Okay.
That gets limited without protections.
Okay, thank you. Ms. Lewis, we have two Lewises. I'll start with you, Ms. Lewis. This committee, I found your testimony very interesting and compelling about the small businesses. And I think we have previously heard from them. Their group, the NFIB, is strongly in support of this bill. And many of them have told us they're afraid to come forward individually because they're afraid of retaliation by the platforms. And we've seen this before, because they can go out of business if they're retaliated against. You work with companies who are stuck in this position. How would the American Innovation and Choice Online Act help them?
Thank you, Senator Klobuchar. The fear of retaliation is significant and really overwhelming for many market participants. It is something that I encountered during the House Judiciary Committee digital markets investigation, and have continued to experience in private practice. It's one of the reasons why I co-founded the Responsible Online Commerce Coalition, because small businesses like Amazon third-party sellers are terrified of the degree to which Amazon has complete control over their economic livelihood and the power to essentially eliminate it overnight. The ACOA very helpfully explicitly prohibits retaliation when businesses of all sizes, and individuals too, I believe, raise concerns about these platforms' anti-competitive conduct, and that is a key provision, and I applaud you for that.
Thank you. Last question, Mr. Lewis. How do you think the bill will affect the strength and competitiveness of U.S. Tech companies?
Senator, I think it will affect it directly. Too many small companies rely on these platforms for access to consumers, and so it's important that they have the ability to reach consumers without having to ask for permission. It's important that they feel free to innovate without fear of their business data being manipulated by the dominant digital platforms. So most of the folks that we talk to, folks that were studied in the House antitrust investigation, folks who don't always want to come forward and share their fears, will say privately that it's important that they have the ability to compete, that they feel restricted by the practices of the dominant digital platforms, and I feel like ACOA specifically targets the harms that we saw studied in the House Antitrust Subcommittee.
Thank you very much. And I just think it's really important to note, as Ms. Lewis was talking about the momentum for the bill, we have had major breakthroughs, including the NFIB endorsement since this started. And these things take a long time. The more and more small businesses that I think that these platforms took for granted that are coming out and talking about what's happening, and including medium-sized businesses and the like, I think it's really important that we note that kind of momentum that we've had in terms of a change of the support that we're getting for this bill as more people understand what's really going on, which in this ecosystem and what's going on around the world. Senator Lee.
Thank you. Thank you. Thank you, Senator Coons. Senator Klobuchar.
Thank you very much, and happy birthday, Mr. Chairman. And I understand you chaired 2 judiciary hearings today. Is that right? You're quite busy. And Senator Cornyn, thank you as well. My state, we are very proud of our long tradition of welcoming immigrants and refugees. Our state has the largest Somali and Oromo populations in the U.S., second largest Hmong population, only to California, and the largest Liberian population, 30,000 Liberians in Minnesota. Our state also has the lowest unemployment rate in the country. We have per capita one of the highest numbers of Fortune 500 companies, depending on the years, 17, 18, 19 of them. And so much of that, when you look at our country and who is running companies right now or starting companies, and who the numbers of people who won U.S. Nobel laureates, you see immigrants and refugees throughout. So I am obsessed with our workforce issue right now. I'm not going to double down on that because I want to talk about the Afghan Adjustment Act. But without refugees and immigrants, we're not going to maintain the competitive edge that has helped us. And that's why I want to pass either comprehensive immigration reform or at least do something when it comes to the Dreamers and temporary status people and add that into the workforce permits, visas, work on the border combined. I just believe that if we don't do something here, when I look at our rural hospitals and doctors that are from other countries, when I look at our hospitality industry, ag industry, we need the workers. So that's where my mind is, but my heart is also with our refugees. And more than 75,000 Afghans who have taken refuge in our country, they're currently in limbo. That's why Senator Graham, the ranking member of this committee, and I joined forces with Senator Coons, Moran, Wicker. These are the lead Republicans on the Veterans Affairs and the Armed Services Committee. Blumenthal, Shaheen, Murkowski, and many other supporters are leading the effort to pass a bipartisan Afghan Adjustment Act to allow Afghans who undergo additional vetting, which is very important to a number of our co-sponsors, that you see this as actually a plus, not only for our country, not only for our reputation in the world, when half of them at least have letters from the chief of mission in Afghanistan for helping our military, whether as translators, security, and the like. So would have a streamlined pathway to a green card. I know that Mr. Kinney, your organization, as well as the U.S. Conference of Catholic Bishops. We have 40 organizations, including the VFW and the American Legion, supporting this bill. It's a huge priority of former President Bush. Can you talk about how our bipartisan Afghan Adjustment Act would help the more than 75,000 Afghans who are currently living in limbo?
Sure. Thank you, Senator, and also for your leadership in this particular area. Every day that an Afghan who we evacuated into the country and did an excellent job, both our multiple government agencies, our communities, and our nonprofits, including our own, who work together on the safe havens to welcome them, should be commended for that work. At the same time, while we have these folks integrating into our societies and cities and counties and finding work and starting lives, every day that they're not secure by having a path to citizenship, or at least a path to permanent residency in this country, they are living in an insecure environment, and it certainly has to be affecting their mental health. In fact, I'm sure it is. I talked to many of them. So this act is critical to securing their place in this country. We cannot send these people back to Afghanistan. We know what's happening with the Taliban. I met many, many young women who were well educated from Afghanistan who came through the evacuation. They cannot go back to Afghanistan. There isn't enough legal assistance there to assist them. The passage of this act, I feel, is common sense and imperative to those who are here and to those tens of thousands that we hope to also bring forward from places like Pakistan, which we discussed earlier.
Very good. Well, thank you very much. And by the way, thank you for your personal story. We are devoted to moving this bill ahead on behalf of those that have stood with our country. So, thank you.
Thank you.
Thank you, Senator Klobuchar.
Babies born alive in his clinic after botched late-term abortions. Gosnell was also found guilty of involuntary manslaughter in the death of a woman who was undergoing an abortion in his care. He was sentenced to life in prison without the possibility of parole. I might remind the senator that this happened while Roe versus Wade was the law of the land. To suggest that it somehow would absolve that kind of conduct is just plain wrong.
Thank you, Mr. Chairman. You don't need to remind me.
Senator Klobuchar.
Ms. Zarowski, thank you for sharing your difficult story with all of us today. As you know, nearly half the states in the country have now enacted restrictions or are moving toward bans. 12 states are enforcing near total bans on abortion. In your testimony, you say that traveling to another state for care was not an option for you because you would have had to drive 8 hours and risk what you called the death sentence of developing sepsis, which can kill quickly in the middle of the West Texas desert or 30,000 feet above the ground. What do you want people to know about the risks that bans and restrictions place on women experiencing miscarriages?
Thank you for that question. So first, I'd like to revisit something that Senator Cornyn brought up in Dr. Scott's response, because I'd like to make it clear that Dr. Scott is not my physician. She has never been my physician. She's never treated me. She has not seen my medical records. Quite frankly, my physician and my team of healthcare professionals that I saw over the course of 3 days while I was repeatedly turned away from healthcare access made the decision to not provide an abortion because that's what they felt they had to do under Texas's law. And that will continue to happen, and it is continuing to happen. And it's not a result of misinterpretation, it's a result of confusion. And the confusion is because the way the law is written, the language in the law is incredibly vague, and it leaves doctors grappling with what they can and cannot do, what health care they can and cannot provide. And if they make the wrong decision, they face up to 99 years in prison and or losing their license. And in my opinion, that was intentional because after the Dobbs decision, the administration put out guidance for when an abortion can and cannot be or should not be provided. And the state attorney general in Texas, Ken Paxton, hated that so much that he sued the government to overturn those guidelines. And so what happened to me is exactly what he wanted to happen.
And your point is that right now we have a patchwork of laws across this country. And if we would enact some federal standards here and codify Roe v. Wade into law, which was the law of the land before this, this wouldn't have happened to you.
That's right.
Okay, thank you. Dr. Verma, how do the medical consequences of delaying care impact women?
They impact women significantly. We are seeing, I am practicing in Georgia where we have a 6-week ban in place, and we're having to turn away patients for all kinds of reasons. People that have irregular periods that don't realize they're pregnant until after 6 weeks, people that are diagnosed, their babies are diagnosed with terrible fetal anomalies on their 20-week ultrasound, people that develop worsening medical conditions during their pregnancies. And because they can't access their care in our state, even though their doctors are trained to provide that care, they're having to figure out if they can go out of state, get the resources together, take time off work, figure out childcare.
And what impact would a national ban on mifepristone have on your ability to care for your patients?
It would have a devastating impact on our ability to care for our patients. We know based on decades of evidence that mifepristone is incredibly safe and effective and can be used in combination with misoprostol for both medication abortion and management of miscarriages. It's an incredibly important treatment for our patients to have available to them.
You know, since Dobbs, states like Minnesota and Illinois have become islands of care in the middle of the country. We are the states that are the islands of care In 2022, Whole Women's Health of Minnesota in Bloomington saw the percentage of out-of-state patients that they treated increase to more than double the numbers in 2019. Since Dobbs, have you seen influxes in patients going between states to access care?
Absolutely. We're seeing patients trying to get out of state to get the care that they need, although we also know that many people are not able to do that and are being forced to continue pregnancies that put their health at risk, that are being forced to deliver because they don't have the resources to get out of state.
Okay, thank you. I'm going to ask one question in my remaining time of you, Professor Goodwin. One judge in Amarillo and 2 on the Fifth Circuit would have entered an injunction setting limits, saying you cannot receive mifepristone by mail, you can't get it over the counter in the pharmacy, that they're going to have it be available not in to 10 weeks, but 7 weeks instead. And as you know, that's currently on hold. And one of the things the Justice Department argued was that the doctors who brought this case, unlike the American Medical Association, that's made it very clear that this drug is safe and it's been used in 60 countries over 23 years in America. The Department of Justice, those few doctors that brought this case, argued that the Department of Justice said they should not be able to sue because they hadn't been impacted by the approval of mifepristone, and they were not going to be impacted in the future, unlike someone say that we've just heard from in Ms. Zarofsky. So I thought this was interesting because, as you know, Justice Scalia has made similar comments to this, where he rejected a lawsuit saying it would make a mockery of our prior cases, that basically you wouldn't have the standing to bring a case when you haven't had harm or expect to have harm. Quickly, do you want to comment on that and what standing really means and why this case should fall on the standing of those that brought it?
The case itself was absurdist. What the petitioners claimed was that the FDA had rushed to judgment with approving this drug. That drug spent over 54 months of review. 2000, it came into the marketplace. Other drugs that were approved in that same period had spent 15 months of review. What we know is that it's safe. It's a drug that had already been used in Europe, and in 23 years since it was approved in the United States, we know that the safety of mifepristone is that it's far safer than penicillin, Tylenol, even Viagra. The claims that somehow these petitioners, including a dentist, will somehow be overwhelmed with patients who have used mifepristone but who will seek their care is truly absurdist, because in 23 years that has not happened. That has not been the experience of the petitioners at all. And it is worth noting that this was a form of forum shopping, looking for a very specific judge who had already articulated anti-abortion views and placing a petition before that specific judge.
Thank you.
Thank you. Senator Grassley?
Dr. Walbenhorst, could you explain how women can still receive compassionate?
Thanks, Senator Grassley. Senator Klobuchar?
Thank you very much, Mr. Chairman. I guess I'll start with you, Mr. Fogel. The Judicial Conference, I think, did the right thing by strengthening the disclosure requirements that apply to judicial officers, including the Supreme Court recently. But the Supreme Court justices are still not bound to the code of conduct, as we've been discussing, for United States judges. Unlike all other federal judges, the code requires that a judge uphold the integrity and independence of the judiciary and avoid impropriety and the appearance of impropriety. How has a formal enforceable code of conduct helped to ensure that the rules are consistently applied for every other judge in the federal system?
Well, who was bound to that for 37 years, both as a state court judge and a federal judge, it really is your North Star. It's what you look at in terms of the values you want to uphold as a judge. And it's something that guides your conduct, and it also is something that the public can look to and say, this is what we expect of our judges.
And do you agree with Judge Ludwig Ludwig, who was just quoted by Senator Durbin, who wrote the committee to say if the Supreme Court does not subject itself to the highest possible professional and ethical standards, it can depreciate its power.
Senator, I agree with that. I think that the Supreme Court, my hope is, the reason I came here today really is I hope that the court will adopt a formal code of conduct. I think it needs to be modified in some respects because the Supreme Court is different in a number of ways, but I think the absence of a formal code is an issue that I hope that they will address.
I appreciate that and your thoughtfulness. Ms. Frost, thank you. You mentioned the Judiciary Act of 1789. You mentioned the Ethics Reform Act of 1989. You mentioned the Ethics in Government Act of 1978 as reasons that, in fact, Congress has passed laws in the past based on the Constitution about the operations of the court. Is that right?
Yes, that's correct.
Okay, so I go over here to you, Mr. Dupree. I really wasn't planning on asking you questions until you dissed the Department of Agriculture. Because you said their court is not just like the Department of Agriculture. And I was looking up, it was set up by Abraham Lincoln in 1862, being a big ag state that we are, 100,000 employees, serves the people of this country. Yet that department, which basically has jurisdiction over what our farmers do for ranching and farming and counter-cyclical payments, I mean, they've got ethical laws in place. So I actually see the opposite when I think about the power of this court. And I think about what Ms. Frost said. I think there is every reason that this court should have ethical rules like the fine Department of Agriculture, and that we don't look at that as a bad thing. We look at it as a good thing.
And certainly, to be clear on the record, Senator, no disrespect to the Department of Agriculture, which is a hallowed department and agency.
You decided that was the department you were going to mention. And I think a lot of people in the middle of the country noticed it, but go ahead.
Understood. Again, no disrespect. My point with regard to the Department of Agriculture was simply that the provision of the bill, and several bills have similar types of provisions where they basically order the Supreme Court to engage in essentially a rulemaking function. In other words, to promulgate for public notice and comment a code of conduct. Again, analogous to what this Congress would say with regard to either the Department of Agriculture, Department of Defense, Department of Homeland Security, you name it. And my point was simply that as a matter of our constitutional structure, the Supreme Court is differently situated in a profound and fundamental way from Article II executive branch agencies, which can be vested with rulemaking power under the Constitution.
Thank you.
Article III can't.
Ms. Frost, you want to reply? Because this gets to the core of this question of us actually being able to pass a law and do anything.
Yes, I mean, this is the point about Article 3 of the Constitution. It's very short. It requires that there be a U.S. Supreme Court, has a few other provisions, but it leaves to Congress that essential role of administering the court. And Congress has always done so. So to question that authority today is to question 230 years of consistent practice where Congress has legislated regarding the court. To be clear, not to control its decisions. That is clearly off limits. But every other aspect of the court is controlled by Congress, from its size to when it meets.
Agree. Mr. Payne, why is it important that the Supreme Court also have an ethics office separate from the individual justices to provide them with advice on how to comply with the ethical obligations and to ensure that this office has the authority to conduct independent fact-finding?
The only way that any current ethics rules or future ethics rules will work is if there's a way to enforce these rules and a way for the Supreme Court justices to understand how they apply. So therefore, you need an internal body that can provide the ethics expert advice and also gather facts in the circumstances where there are potential violations that need to be resolved.
Ms. Frost, what do you think on that?
Yes, I would agree with Mr. Payne's analysis there, and I think that one of the problems we've been having today is that so many of these issues get dug up by investigative journalists and splashed across the news in ways that does damage to the court. If they had a more systematic method of adopting or approaching these problems, we could avoid this.
And Mr. Fogel, how would you handle that? Because you've been, trying to thread the needle here.
No, I am trying to thread the needle. I think the court's independence is very important. I agree with other witnesses who have said that. I think there are ways they could do better at getting independent and impartial advice about ethical questions. They don't really have, it's kind of a black box, as I said in my written testimony. They have a lot of sources and rules that they follow, but no one really knows what they are, and I think if they had a internal resource, I suggested, and I'm not alone in suggesting that they get a group of very experienced retired judges whose integrity is unquestioned. And I stress retired judges because then they're not subject to the problem that a circuit judge would have or a district judge would have. To just say, look, I have a question here, I'd like your advice. I mean, what do you think? Somebody who's independent, who doesn't have any skin in the game and can just say, yeah, I think this is okay, or I don't think that's okay. I think that's a modest step that the court could take.
Okay, well, thank you. And Mr. Mukasey, I'm sure we can talk about this in the future as my colleagues await, but you and I have worked together well, including when you were Attorney General, so thank you.
Thank you very much.
I'll get started, and I want to thank Senator Tillis, Senator Blumenthal for being here. And Senator Blumenthal, we mentioned your leadership on the App Store bill. Thank you. As the daughter of a newspaperman, I have watched closely as local journalism has seen its content and ad revenue siphoned off by digital platforms like Google and Facebook. You mentioned this, Mr. Kent. How has Google leveraged its monopoly power to squeeze publishers like local newspapers out of ad revenue that they would receive if there was a competitive market?
Over time, Google and Facebook, Google in particular, have absorbed most of the incremental growth of the industry, and they've done that by a pervasive collection of data across the web. Google has tags and pixels and listening devices basically on nearly 80% of the top 1 million websites. Facebook does across 8 million plus websites, according to regulator data and research. So they're collecting and mining data across the web and using that to generate the most profits possible because they dominate the supply chain.
Mm-hmm. From your perspective, working directly with publishers, what are the biggest threats to publishers from a few tech giants controlling almost every aspect of the tech ecosystem? How are you addressing those threats?
Well, antitrust is key to us because most of the downstream harms that we've seen, whether it be lower quality content, disinformation, not being able to fund journalism in newsrooms, data abuse, concerns about censorship and the way those are all downstream harms from what's upstream, which is a perverse amount of market power by just a couple companies. And so anything in the area of antitrust or data protection that actually aligns the consumer's interests with the content and the news and entertainment that they actually want to consume is very valuable. Other legislation like what you're working on with the JCPA, where there's a duty then to correct imbalances in bargain power, is also very important to the future.
Okay, thank you. One of the concerns that we have discussed here, and I've heard from both publishers as well as advertisers, is that there's no way to verify limited data that Google and Facebook provide about where ads are shown, to whom, and for what price. Even you, Mr. Henderson, Professor Henderson, that doesn't agree with this bill, have noted that transparency is a good thing. One example of this, Facebook was sued by advertisers in 2018 for lying about how many people an ad could reach. What information about ads do you think should be provided to advertisers and publishers by ad platforms? And the secondary question, how has a lack of competition empowered Google and Facebook to limit transparency? So why don't you get at that? Because I believe that this bill would help give advertisers greater insight into what's going on and whether their digital ad campaigns are even effective. It's hard to know. So anyone want to take any bit of that about what information you think it should be provided, and also what we could do better?
Sure, thanks, Senator. One thing that Professor Henderson mentioned, and this is sort of thrown around a lot, is that the price of ads has just gone down. So nothing to see here, folks. One of the things that the bill does, which I think is great, is it requires brokers to disclose certain information to advertisers. And that information will allow them to audit whether what they're buying is good quality or whether what they're buying is bad quality. And so one of the things that might happen is finally we'll be able to actually measure whether in fact the effective price of ads is going down or whether it's going up.
Can I just add one other small comment, and that is that, you would think that the publishers and the advertisers would both know what the price was for the impression that was sold. The advertisers know what they paid, the publishers know what they received, but neither the publisher nor the advertiser know what the costs in the middle were. And so there's a disjunction of knowledge about what publishers received and what advertisers paid because this intermediary margins are really, really large. And it would be like having a stock trade without knowing what the ultimate price was, or a sale of a home without a closing sheet. And so that's a very simple example of transparency.
Mr. Lin?
Yes, thank you. In an earlier life, I ran a magazine called Global Business. It was a 100,000 circulation magazine. It was 4-color, perfect bound, 96-page, monthly magazine. We lived 100% off of advertising. One of the things that we did in this this period a long time ago is we spent about 7% of our revenue every year auditing our readership to make sure that advertisers understood exactly who they were getting and how they're getting it. That was a long time ago. That was essentially before the internet. I would say that advertisers back then were better served than they are right now.
Okay, very good.
Oh,
Yeah,
go
Mr.
ahead.
No, go,
No,
Professor
please.
Henderson. I'll go back to, I have one last question. Our colleagues have to.
Okay, I just want to add, I said I was for transparency, and I think that's fine. I think, Louis Brandeis said it well, shine a light on things, as you said, Senator Klobuchar, when we started. I should note, though, that's a little bit misleading because, as I mentioned, Google, the UK Market Authority found that Google's rate that they charge is in line with their competitors. And if nobody had any idea how much these intermediaries were taking, they would have incentives to jack, Google could get away with charging anything because nobody knows what they're charging. They're charging a market rate, the market rate of their competitors. And I'll note that the average large publisher will use 6 different ad platforms in a year, and the average advertiser will use 3 different platforms. So it's not like this is the only game in town. And if Google is fleecing everybody, I'm from the University of Chicago, so I'm contractually obligated to say that I believe in markets. And if Google was absolutely fleecing people, given that the average person uses 6 or 3 or 6 different other ad alternatives, they would be taking their business to those places. Now, if they are, as you said, Senator, committing fraud by deliberately misleading people, then we should have no tolerance for that. We should go after them.
Yep.
But the threshold for breaking them up, I think, should be a lot higher than that.
Okay, Mr. Kent, you want to respond?
I was just going to say that, I heard the point earlier from Professor Henderson why stocks are different than advertising. I don't think we're arguing they're the same thing. But advertising in digital is a high volume. We heard the numbers from Roger that the volume of advertising impressions per day at that rate, the average ad translates to about less than a penny per advertising. That's ripe for fraud. Those are the types of markets, large volume, low price. A CEO of an ad tech company recently told me that Google and the Trade Desk are non-transparent black holes. Nobody has any clue what's going on inside them. And so we need to actually have some transparency because the way it translates is that local publisher gets a check every month from Google, and they have no idea what's behind it.
Okay, one last example I want to use of my own experience with this. And why I know that they have info and they're targeting people. One of the ways that Google is able to leverage its market power to disadvantage its competitors is by drawing on that vast amount of personal data it has on people, as well as the lack of any federal privacy legislation to limit how it can use the data. So you have this twofer problem. So I wanted to show this ad only because, so this is a pop-up ad against the self-preferencing bill. Okay, and I only find it funny because I do want to thank the lawyers of Google who put that little could in there. So it says, Senator Klobuchar with the little, my colleagues will enjoy this, could break Google Maps, okay? This gives me a lot of power, Senator Lee. What?
Just the context froze me.
Yeah, I know.
You don't want it to suggest you could break. That's not the message.
Well, that's exactly. I do wonder about it. And if we want to look at the other ones and show these, I'm going to get to the punchline in a minute. These are harder to see, but these went all over the place. That I would erase Amazon Basics and that I would break. This one is interesting. Another little could break FaceTime. Okay, so who saw these? Members of Congress saw these. So these were targeted in Washington, D.C. for members of Congress when they were home against the bill, and this is part of the over $200 million advertising campaign put forth by Chamber of Progress, or as I call them, Chamber of Lack of Progress, which is the big tech companies' front group. And so, but what is interesting to me is I heard about these ads from who? Other members of Congress. They were targeted, so they saw them. I'm not going to put their names forward on this thing, but I had multiple calls by members of Congress. So I guess I would ask you, Ms. Srinivasan, if that surprises you, that they would be able to have this data to target people so they scare them from supporting our bills, because they don't want to have these really scary ads that they're breaking into be put up on sites where people are just looking up TV shows like I was doing. Okay. Go ahead.
It doesn't surprise me. When Google bought DoubleClick way back when, one of the things that it promised to do was to keep customers' data separate. Of course, it purchased DoubleClick, and then after it gained market power, it started to use that information, and it can use that information now for different trading purposes, whether it's to hyper-target ads like that. That is data that's originated on the publisher side, on the seller side, that Google is gaining by virtue of its position as publisher's broker, and now it's using it on the other side to target ads and to inflate its trading revenue. And so that's one of the things that this bill would target and prohibit.
Exactly. And of course, the ultimate interesting part is they're using it to target people on a bill, using their own monopoly power to target a bill that tries to do something about their monopoly power. So I just think it shows what we're up against, but it also has to be revealed to the public. So with that, I'm going to turn over. Thank you very much, Mr. Chairman. Thank you, both of you, for your work. I think that whether it is in the agriculture area, whether it's in manufacturing, whether it is in our nursing homes or hospitals, it is very clear that we need reform. I am been a long supporter of comprehensive immigration reform. I thought it was part of the original deal we had back when Bush was president, where we had a few Democrats in the room, and we also had Senator Graham, I remember, in the room. Then we had the bill that when Senator Grassley and Senator Leahy were leading the committee that passed through this committee. And then recently, Senator Rounds, during President Trump's time, led a group that we came up with an agreement that would have greatly helped on this front, but unfortunately, President Trump didn't support it. And so now we are where we are, and three times we came close. And I believe we need a reform that includes agriculture workers, but also includes other things like doctors and nurses and healthcare aides and the like. And I just don't think we're going to be able to wait anymore. I'll start with you, Mr. Lynch. You discussed how you've been unable to fill all of your job openings with American workers. Last year, Minnesota had 6.9 job openings for every 100 jobs in the state, the third highest job vacancy rate since the state started tracking data. It's the number one concern I hear in rural Minnesota, not just in ag, but with restaurants, manufacturing, and the like. I'm proud of our good economy in our state, but it's getting to the point, especially in some of our healthcare settings, where we simply don't have enough workers. As a business owner, could you talk about what challenges you faced? And also, last year, Senators Cornyn, Coons, Tillis, and I urged the administration to fix the backlogs that keep seasonal workers and businesses that rely on them waiting. Could you talk about that and what happens when there's a processing delay?
I'll be glad to. Thanks for the question. Similar to the story that Chairman Durbin shared about Shay Myers mentioning a couple years ago, his issues with asparagus, we had the same issue on our farm December of 21. We had 120 workers scheduled to come on December the 10th. There was delays at the State Department processing their visas. Most of workers that were all returning. We had about 160 acres of broccoli that was ready to harvest that we completely lost. We're unable to harvest. Our loss on that field of broccoli, or those fields of broccoli, totaled somewhere around $600,000, which was a significant hit on our crop and ultimately led to us losing pretty significant money for the season just because we lost that much because we did not have the workers to harvest it. So I think one of my concerns going forward with the new OEWS wage desegregation, and one of the issues that could create is like one of the issues that Chalmers mentioned on the increase in applications. So I think a lot of employers are looking to do that. They're having to desegregate, list these different jobs on different contracts. And I'm worried that there's already significant delays within both DOL and at the State Department that this could create an even worse backlog. So that's a major concern going forward.
Okay, thank you. Ms. Tellefson-Torres, you talked about human trafficking and how there have been ag workers that have fallen victim to that. Senator Cornyn and I led the Abolish Trafficking Reauthorization Act. Clearly a priority of this committee to move forward. What additional protections are necessary to protect farm workers from human trafficking?
Well, thank you for the question, Senator. Well, we're here also talking about the need for legalization with a path to citizenship for farm workers who are here undocumented. We're talking about the dignity of all farm workers, and so H-2A workers who are coming into this country need to be able to understand that they can enforce the law themselves. And so this is why there is a need for equal rights, for the opportunity for H-2A workers to enforce their own rights, and really impose joint liability between employers, farm labor contractors, and recruiters to prohibit recruiting fees, prohibit wage theft, to ensure that all of the different layers within the ownership and the people who are employing these folks understand that there shouldn't be any shenanigans, that farm workers are here and need to be protected. So we really feel that it's necessary to have H-2A workers be part of the Migrant and Seasonal Agricultural Worker Protection Act. They're excluded at this point. We're not sure why. Why are farmers who have only domestic workers having to abide by this act, and those who are bringing in H-2A guest workers not having to abide by one of the only federal protections that covers farm workers? Okay. And so there's a lot that needs to be done.
Oh, that's for sure. So thank you. And I do hope, Chairman, as we work on these, that we also, in addition to getting the Farm Workforce Modernization Act that I strongly support, that we look at other issues I raised with H-2Bs, with the healthcare area, our Conrad 30 bill and the like. When we look at this, we look at other areas as well where we need to add more workers. It's just becoming a near crisis point in my state.
Thank you. I yield.
Senator Klobuchar.
Thank you very much, Mr. Chairman. Thank you, all of you, for your good work. I'll start with you, Deputy Director Cohen. I know Senator Whitehouse asked Mr. Olson about the use of 702 when it comes to drug trafficking, and I wanted to kind of dig down on that just because we're seeing more and more fentanyl kill people, and also more available on the internet, sometimes, many times unknowingly, when people are purchasing other pills that shouldn't be on those platforms. Without getting into specifics, how is data collected under Section 702 been used to disrupt trafficking networks and prevent fentanyl and its precursor chemicals from entering our communities? What work is being done?
Thank you for that question, Senator Klobuchar. So we use Section 702 collection on foreign persons overseas, query the database to identify individuals tied to organizations that are involved in drug trafficking and in fentanyl production in particular. It helps us illuminate where the precursor chemicals are coming from, often from China, how those chemicals get to overseas, oftentimes to Mexico, not invariably, but oftentimes to Mexico, as well as how some of the pill presses that are used to manufacture fentanyl are acquired again overseas and brought into Mexico for use, including by organizations such as the Sinaloa cartel.
And I think that's really important to know for those just talking to families who have lost kids who purchasing drugs on the internet, that the platforms are being used by these cartels. You don't have to go into that, but these cartels are actually involved in this, so it's not like they can get all their justice in the U.S. And in order to stop this, we're going to have to stop it from coming in, the ingredients and some of the other substances. Is that correct?
That's correct, Senator.
Okay. Deputy Director Abate, I appreciated Senator Durbin's words about making sure that these reforms continue and that they are, I appreciated what you announced today and that there'll be changes to the existing 702 authority. Could you talk about how the reforms the FBI implemented resulted in measurable improvements in the FBI's compliance, number one, and then number two, is there a lag in the publicly available data such that the most recent FISC Section 702 certification does not accurately inform the public?
Thank you, Senator. Yes, with respect to the reforms that we've already put in place, as the Assistant Attorney General noted, we've seen significant progress. Just the one that Mr. Olson cited on having our personnel opt in year over year resulted in a 90-something% decrease in overall U.S. person queries. So we've seen significant progress there, along with the other reforms that we've implemented. On batch queries, which are anything more than one, we had put in place a requirement that for any batch queries over 100, it require attorney review from our Office of General Counsel. I've taken that even further now because I saw some recent examples, again, where I was disappointed in the compliance error. So we've actually cut that down now so that any batch query of any number is going to require attorney review from our Office of General Counsel going forward. We're also requiring written justifications for our personnel when they're endeavoring to make a U.S. person query. And we're going to continue to iterate on that. We view it as an ongoing process, and we're open to any and all further reforms in working with the committee and members here. And we're not going to stop until we've achieved 100% compliance.
Okay. I was going to ask Mr. Olson if you wanted to add anything, but before that, quick, how has the FBI used Section 702 to critical infrastructure and businesses to protect them from ransomware and other cyber threats? Because we certainly have been seeing a surge in those.
Yes, Senator. As we said, it's a vital tool. Some examples have already been provided. It's with regularity that we see that. It's helped us literally identify potential victims in the United States, both individuals and companies who are either being targeted for cyber attack or in the midst of an attack, already have been. It's allowed us to get in front of that, particularly with regard to our critical infrastructure, to warn victim companies before they're hit and prevent the harm from occurring from adversaries like China, Russia, Iran, North Korea. And it's been, without it, we would not have been able to achieve that goal. And,
okay,
to
because
protect
you
our
had some
country,
major
protect people.
prosecutions. Could I just, just ask Mr. Olson, it appeared he had something you wanted to add on the reform front?
If I may, just 2 quick points, Senator. One, on your cyber question, one example is the notorious Colonial Pipeline attack, where 702 collection helped us both identify the hacker and it enabled us to recover most of the ransom money that had been paid. Secondly, your question about the certification and the FISC opinions, there is a 2023 opinion that is now going through the declassification process that will come out shortly, and which does identify some additional improvements in FBI compliance. Not 100%, there are still problems and things that we're still working on. That's part of the deal. but it does identify that the FBI has continued to improve its compliance over the past year.
Okay, thank you very much.
Senator Cornyn?
And talk about something that I think it's important, given my background as a prosecutor, that we don't forget, and that is the attacks that we've seen, the unprecedented number of attacks on LGBTQ Americans. We know that LGBTQ Americans continue to face violent attacks, and there's hateful rhetoric dehumanizing them, and that is one of the contributing factors. This year, the FBI found that crimes motivated by bias against LGBTQ people represented 20% of all reported hate crimes. This is close to my heart because when I was a prosecutor, I'd never even been in, I remember the White House. President Clinton was president, and he introduced the hate crimes bill, and I got to meet the family of Matthew Shepard. They were there along with the police who investigated the case. And I think that was a moment for America that kind of flipped how people thought about things and realized that he was just pursuing his own life and ended up, as the investigators described it, looking like a scarecrow, someone thought, pinned to a fence. Could you talk about what trends you are seeing in LGBTQ hate crimes? And why don't you answer that first?
Yeah, the reality is scary. I mean, we're sitting here 7 years since the Pulse nightclub shooting where 49 lives were stolen, and just over 7 months since the shooting at Club Q that stole 5 lives from the community. This uptick of violence is real, and you've said it already. 1 in 5 of every hate crime is motivated by anti-LGBTQ plus bias. The other reality that we know is true is that these bad bills targeting the community are often accompanied by campaigns of misinformation and lies that sow fear and transphobia in communities. The very fact that we can't identify Leah Thomas as a transgender woman is playing into the fear and anxiety that's motivating these hate crimes. I talk to people every day. I talk to pediatricians that are being escorted to their cars by armed guards because of the bomb threats that they're receiving. I talk to drag queens who are being confronted by Proud Boys with AR-15s outside of drag queen story hours. This epidemic is real and requires action, both legislative and also cultural, in stopping this ability for people to just spout lies about our community.
Thank you. You mentioned Minnesota in your opening remarks, and I think what we've seen over the last few decades, we have seen progress in the fight for equality. The bipartisan group that worked on the Respect for Marriage Act, led by Senator Baldwin, and we so appreciated her work and how she worked with people on both sides of the aisle to get that done. But half of LGBTQ adults still report experiencing workplace discrimination based on their identity. Could you talk about the Equality Act, why it's important? And specifically, are there still places in the U.S. where an LGBTQ person can be denied a home simply because of who they are? Is that correct?
Yes, absolutely. Right now, there are only 23 states that have explicit non-discrimination protections on the books for the LGBTQ plus community. What that means is I could go into a restaurant in Texas and be denied service because I'm married to a woman. It means that some members of the community can experience discrimination in housing and getting access to federally funded colleges and programs. This is really a crisis. We need to make clear that in this country, there's not a patchwork of protections based on your identity. Every American deserves equal access to civil rights and non-discrimination protections. The Equality Act will move forward that into law.
Mm-hmm. And I know there's major companies supporting the bill, that there's been a lot of support for it. One other question along those lines, are there still places in the U.S. where an LGBTQ person can be denied a loan even because of who they are?
Yes, there are.
Okay, very good. Could you talk about some of the progress? You mentioned Minnesota, but some of the progress that have been made in states on a state-by-state basis, which I think shows how, in fact, there are a whole lot of people out there who support the work of HRC and bills and state versions of bills like the Equality Act. I know that my state, as you mentioned, has been a leader. We were a leader on anti-discrimination from the very beginning. In 1993, we began protecting LGBTQ people against workplace discrimination. We were the first state in the nation to outlaw discrimination based on gender identity. So could you talk about progress?
Absolutely. There has been incredible progress for our community. You know, if I look back 20 or 25 years, 60% of Americans opposed same-sex marriage, and now nearly 80% support same-sex marriage, and the Respect for Marriage Act is the law of the land. That changed because we were able to serve openly in the military. That changed because we were able to tell the stories of our lives and show what our love looked like. That changed because now the majority of Americans know someone who is lesbian, gay, or bi. We need to make sure in this fight that we're not letting people's lack of visibility seed into fear, and instead tell the stories about trans women, tell the stories about trans men, show the stories like Harley's that show that at the end of the day, these are simply Americans who are trying to live. That's what we're fighting for.
Okay, well, and thank you to all the witnesses. I wish I could ask you all questions, but my colleagues are waiting. Thank you.
Thanks, Senator Klobuchar. Senator Blackburn.
Okay, very good. Thank you. I was glad to be here for all your testimony, and thank you for that. I guess I'll start with you, Mr. Harleston. Approximately, I know you talked about this a bit with some of the other senators, Senator Blackburn, approximately half of the states have laws that give individuals control over the use of their name, image, and voice, but in the other half of the country, someone who was harmed by a fake recording purporting to be them has little recourse. In your testimony, you talk about new laws and how they could protect musicians' names, likenesses, and voices, the right of publicity, I think you called it. Can you talk about why creating this is important in the face of emerging AI, and how have statutes in states that have these protections helped artists?
Thank you, Senator, for the question. It is critical in this environment when we're talking about the creative expression that the artist has made, that the right of publicity also be extended at the federal level. There is inconsistency, but more importantly, the preemptive element of it is critical. Raising it to the level of an intellectual property is also critical. What we've seen, and this is really in the area of deep fakes, where you've seen, I think Ms. Ortiz referenced how many times her name was listed. We're finding with our artists, particularly the ones that are most established, that their names are daily hundreds of thousands of posts with their names, and also there's sometimes images that are used as well. So it's critical to have this right to protect the artists and their use. And if I could just say one thing on the I know this is not your question, but I have to say it.
There we go.
Because it's killing me.
I'll just add it to my time.
All right, thank you. It's on the opt-in, opt-out. There's an element beyond commerciality, and I want to make sure everyone understands. As Ms. Ortiz did reference it about she probably wouldn't want a license to an AI, and there are, we have artists that don't want a license to streaming services. So it's not always about the commerciality. Some artists just don't want their art distributed in certain ways. And the Beatles didn't come on to streaming platforms till about 7, 8 years ago. That was a decision that was very important to them. So I want to add that into the conversation. I know that wasn't your question.
Okay.
Sorry.
Okay, very good. And so what do you see as the obligations of social media platforms on this?
With respect to AI?
Uh-huh.
Oh, great, fantastic question. We believe that the social media platforms absolutely have an obligation. I will say this, that we could help them by giving them a hook beyond copyright in terms of being able to take down some of the some of the deep fakes.
Yeah.
We've had challenges with some of the platforms in this.
Right, exactly. And I think we're seeing the same thing. I guess I would turn to you, Mr. Brooks. You talked about advocating for creative ways to help people identify AI-created content. When we talk about deep fakes, we're already seeing this with political ads and not even paid ads, just videos that are put out there. There was one of my colleagues, Senator Warren, that was just total lie, that saying that, acting like it was her, that she was saying people from one party shouldn't be able to vote. We've seen it in the Republican presidential primary. A number of us on a bipartisan basis are working on this. I chair the Rules Committee, so this is kind of my other hat. Do you agree that without tools for people to determine whether an image or video is generated by AI, that would pose a risk to our free and fair elections if you can't tell if the candidate you're seeing is the candidate or not?
No, thank you, Senator. Look, we absolutely believe that these transparency initiatives, like CAI with Adobe, are a really important part of how we make the information ecosystem more robust. This isn't just an AI problem or a social media problem. It's going to require everyone, and it's going to require accountability right across that ecosystem. But what we think is, we have in place things like metadata, things like watermarking for content. They're just some more of the signals that social media platforms can use to decide whether they're going to amplify certain content. And that's
Yes, and we've got this Real Political Advertisement Act with Senator Booker and Senator Bennett. There's a version initially that was also introduced in the House, and so that's one solution, but we're also going to have to look at, I would say, banning some of this content, because even a label or a watermark, if it's not going to help the artist or the candidate if everyone thinks it's them and it's not, and then at the end it says generated by AI.
Yeah. It's a great question, and a really important one, I think, Senator, because there's a few things in there. I think there's the question of the use of likeness, particularly for improper purposes, where you're implying that there's some kind of endorsement or affiliation between a particular person and a particular work or idea. That is different, I think, to the use of the kind of free experimentation with style and some of these other issues that tend to get lumped together in AI outputs.
Mm-hmm.
And so in terms of these scenarios that you're talking about, there is this kind of improper use. You're implying that someone endorses or embraces a cause or a work that they're not affiliated with, and there needs to be clear rules around how likeness is used in that context, whether through right of publicity or through some of the bespoke deepfake legislation.
Okay, last, Mr. Rao. Our recent study, and I know you've worked on this democracy issue, which I truly appreciate, a recent study by Northwestern predicted that 1/3 of the U.S. newspapers that existed roughly 2 decades ago will be gone by 2025. The bill that Senator Kennedy and I have, the Journalism Competition and Preservation Act, would allow local news organizations to negotiate with online platforms, including generative AI platforms. This bill passed through this committee now twice. Could you describe how Adobe approaches this issue? And in your experience, is it possible to train sophisticated generative AI models without using copyrighted materials, absent consent?
Thank you for the question. Absolutely. Our current model that is out there is trained using the licensed content that I had mentioned before, and other content that has no restrictions on it, and it comes from the right holders directly. So we definitely think it is possible. We've done it. It's out there on our website, and it's also in Photoshop, and people love it. The creative professionals are using that AI. It makes their day easy. It lets them start their creative work in just one click, and then they finish it in the tool. So it's really revolutionized how we think about things in terms of how we acquire data sets. We have a group inside Adobe who that's their job. Their job is to think about, where do we need to go next? Do we need to get to different media types? Are we missing some sort of subject matter for our AI to be more accurate? That was a question we had before. We think about that content. Maybe there's a newspaper that you mentioned that has the kind of content we need. We go approach that organization and say, look, we need to license that content in to make sure our AI is more accurate. So we have a team that thinks about this, sources it, and brings it in.
And in the absence of that, I mean, what impacts do you anticipate this could have on local journalism if there's no rules of the road put in place?
Yeah, I think that, both on the authenticity side and on this side, if people are able to, create images and these newspapers are not able to get, the ability to license the work they're doing, it could certainly have a negative impact to them. On the authenticity side, the reason why so many media companies have joined the Content Authenticity Initiative, like AP, Reuters, Wall Street Journal, New York Times, Washington Post, is because they know that when they're showing images, they need to be able to show that they're actually true. Mm-hmm. They need to be able to prove that it happened. If people stop believing that any of the digital images they're seeing are real, then they're going to stop consuming newspapers. They're going to stop consuming that content because they're not going to believe it. So you have to give those local newspapers a way to prove what they're showing is
Right.
true, so people will still consume it.
Of course, there's a lot less famous newspapers, including some very small ones in my state that just you might not mention, right? And so I think that's part of it, is that the Ms. Ortizes of the story need to be able to have some kind of power to be able to protect their content too, because they don't have a general counsel and they're not going to be able to, on their own, start some major lawsuit. And so I think that's how we have to think about that too, as we look at all of this.
And that's why I would say again that when we designed the Firefly, we designed it that way, right? To be commercially safe first, right? Making sure that we built the model the way.
Yeah, no, I'm not, I'm saying it sort of rhetorically to the world and to everyone that needs to get this done, as opposed to you, Mr. Rao. So thank you
so much.
All right, appreciate it. And thank you, both of you, for your continual bipartisan work in taking on this.
To do its part in this fight. Thank you.
Very good. Thank you very much, Ms. Slayman. Mr. Lee, Senator Lee has come back from another hearing of some kind. We're joined by Senator Hirono and Senator Tillis, who I know went to vote. But I thought I'd start with you, Mr. Dalrahim. As Assistant Attorney General, you voted for the department. You advocated, I'm thinking of votes, you advocated for the department to stop waving through harmful mergers based mostly on promises from the company. Can you explain why, in your view, it's important to block anti-competitive mergers instead of just rely on promises?
Thanks for that question. I think a general view is what is exactly the design of the agencies. My view of antitrust enforcement is, in its best form, it's really a law enforcement function and not a regulator with the central planning type of tools for ongoing interference with the market. I viewed that if there was a problematic part of a merger, there should be a remedy, a structural remedy would be preferred, and the government gets in, government gets out. But with that, also means that you do not slap yourself on the back with some promise where there's not a problem in a merger just because merging parties are willing to pay that tax and get a merger through. So, it was a two-sided effort to create efficiency. I think there are times, but rare instances, where behavioral remedies, if there's not a structural remedy available, that could preserve the pro-competitive benefits of a merger that should be accepted, but otherwise, should be litigated. AT&T, we had, I think it was a matter of public record, either selling control of DirecTV or Tribune were on the table. Had those been accepted, and I'm sure the executives wish they had now, that transaction would not have posed the foreclosure concerns and raising rival costs that we thought it had.
While you were Assistant AG, you stated that the risks from vertical mergers are heightened in digital markets, especially if data plays a role in designing products or services for consumers. Can you explain why some experts believe digital markets may be especially vulnerable to harm from vertical mergers?
As I think has been shown, one of the concerns is potentially the network effects that could be caused. But it's not present in every transaction. Every single one is fact-specific. And we have to take a look to see, is the transaction intended to block somebody who is going to disrupt the market power that the underlying digital platform may have? With that, you would hope that preserve the competitive forces rather than them. And we had, I think, 2 days of hearings at Stanford Business School to look exactly at that, and there's a body of record about that. That was one of the reasons I had made that comment.
Mm-hmm. Okay, thank you. Dr. Rose, can you talk about why many economists now accept that vertical mergers in concentrated industries can be harmful?
Sure. So I think let's look at a kind of
simple situation where you've got a firm that is participating in a concentrated market, and let's assume that it's got a reasonably sizable position in that market, and now it's thinking about buying someone else either upstream or downstream. And the concerns that economists have raised, first from a theoretical perspective, and this goes back to literature in the 1980s and 90s and forward, and increasingly in empirical analyses, is that that type of merger may give the firm, the combined firm, the incentive and the ability to exercise its market power through something like raising its rivals' costs, so making its rivals less effective competitors and enabling that firm to increase its profits, and in the process of doing that, raise price to consumers, or foreclosing rivals from competing altogether. And it's not just price, it can hurt consumers through innovation as well. So I'd give an example of a merger, a vertical merger that came to DOJ when I was there between Lam, a semiconductor equipment manufacturer, and KLA-Tencor, a company that produces the metrology equipment that's needed to make sure that your manufacturing equipment is really capable of meeting the very precise tolerances that the chip manufacturers, the innovative chip manufacturers like Intel, need. That was a merger where the companies came and said, well, this integration is going to create all these efficiencies and innovation and make it more effective. And what we realized as we looked at this is that it gave the combined company the ability to deny access to the KLA-Tencor metrology equipment, not necessarily permanently. Maybe all it had to do was deny access to the Lam competitors for a few months. But that would be enough to disadvantage those competitors, leaving them behind in the race to produce equipment that could manufacture the new generation of chips. And that there, to Mr. Dellerham's point, was really no way that you could write a conduct remedy that would prohibit the company or exclude the company from denying that access in something as simple as just, maybe it was just a little slower to tell rivals about this new measurement equipment that was available. I think that's the problem that we face, is that when the company has both the incentive and ability through its acquisition of an upstream or downstream firm to disadvantage rivals, it's compelled to use that market power. And I think that's the understanding that economists now have of many vertical mergers. Not all, but many, especially in oligopoly markets.
I think that's an important point. Okay, Live Nation, Ticketmaster, brought it up at the beginning, Ms. Slayman. In 2010, the DOJ allowed Live Nation to acquire Ticketmaster after Live Nation promised not to use its music promotion business to force venues to use Ticketmaster for ticketing services. 9 years later, the DOJ had to step in and set new terms for Live Nation after the company repeatedly broke those promises. And earlier this year, the New York Times reported that the DOJ is investigating Live Nation for continuing its unlawful conduct. And we hope that our hearing and the information that we gathered at that hearing will be helpful for that reported investigation. Ms. Slayman, in instances like the Live Nation merger, where a company later reneges on an agreement that was key to the decision to approve the merger in the first place, even though many of us raised issues with it at the time, I'd just like to note for the record. But when the company later reneges on an agreement that was key to the decision to approve the merger in the first place, how are consumers generally harmed?
Well, it very much depends on the details of the situation. It became so clear in the Ticketmaster case that consumers were not well served by the lack of competition against Ticketmaster. I think Taylor Swift felt the need to talk about why this terrible consumer experience happened to her fans. And one of the things that she mentioned was she likes to take as much of this process in-house as she can, and with Ticketmaster, that wasn't an option. I think that's because of these exact agreements, because Live Nation has such strong control over the venues. As someone doing a nationwide tour, the Eras Tour is happening across the country. She needs a lot of different venues. She has to work with Live Nation, and as a result, she had to work with Ticketmaster.
Right. And as during the hearing, it's not just her. It's
of course
the examples from Bad Bunny to Bruce Springsteen to Clyde, who was our witness of the Clyde Lawrence band. So, I mean, the point is, even for the smaller bands, it's actually a lot harder because they aren't making that kind of money. And we learned in the hearing that they have that Ticketmaster, it's like 90% of the venues for the largest events, for things like the NFL, NHL, 80% when you break it down to the next large events, and 70% of events overall. This is just by memory, but I believe that's what it was. So do you agree that the Ticketmaster Live Nation merger has ended up harming consumers, and if so, how? And then I'll turn it over, and I'm going to go vote and turn over to Senator Lee in return.
Yes, it has ended up harming consumers, and I believe that that was foreseeable at the time, as it sounds like you did as well. So what's important here is that the result is that it's very difficult to compete in ticketing. So we don't have alternatives to Ticketmaster, and there isn't that competitive pressure on Ticketmaster to provide a better service to consumers.
All right, thank you very much.
Thank you, Madam Chair.
Woman of action, I hope, Senator Hawley.
Definitely a woman of action and someone who has invested a lot of time.
Yes. Well, I just want to thank both of you for doing this. I mostly just want to hear from the witnesses. I do agree with both Senator Blumenthal and Senator Hawley. This is the moment. And the fact that this has been bipartisan so far in the work that Senator Schumer, Senator Young, are doing, the work that is going on in this subcommittee with the two of you, and the work Senator Hawley and I are also engaged in on some of the other issues related to this. I actually think that if we don't act soon, we could decay into not just partisanship, but in inaction. And the point that Senator Hawley just made is right. We didn't get ahead of the Congress didn't get ahead of with Section 230 and the like, and some of the things that were done for maybe good reasons at the time, and then didn't do anything. And now you've got kids getting addicted to fentanyl, and you've got off that they get online. You've got privacy issues. You've got kids being exposed to content they shouldn't see. You've got small businesses that have been pushed down search engines and the like. And I still think we can fix some of that. But this is certainly a moment to engage. And I'm actually really excited about what we can get done, the potential for good here, but what we can do to put in guardrails and have an American way of putting things in place and not just defer to the rest of the world, which is what's starting to happen on some of the other topics I raised. So I'm particularly interested, which is not as much our focus today, on the election side and democracy and making sure that we do not have these ads that aren't the real people. I don't care what political party people are with, that we give voters the information they need to make a decision, and that we are able to protect our democracy. And there's some good work being done on that front. So thank you.
Let me introduce the witnesses and seize this moment to let you have the floor. We're going to be joined by Dario.
Thank you very much, Mr. Chairman. I'm going to ask a few additional questions, and at some point I think we'll, and Senator Blumenthal does, and then hopefully Senator Lee will return for a bit, but then we have to go back so we don't hold up additional votes. I'd start with, I know you, Ms. Sliman, mentioned the bill that we passed, the Merger Filing Fee Modernization Act, which I appreciated Mr. Delrahim, when he was in his old position, was advocating within the administration to get this done. And we finally got it done with a little drama, I will say. The bill that Senator Grassley and I had for a long time at the end of last year. We also passed a bill that Senator Lee had about the venues of cases that they stay, supported by nearly every attorney general in the country, from liberal to conservative, that the cases stay in the states where they are supposed to stay. That was a bill that Senator Lee and I did. But if we could go back to the funding that we had then take effect immediately after some debate, and we actually had a floor vote and got nearly, I think, 90 of the senators to vote for that. How do you anticipate that the agencies, they got this support? Why is it helpful with regard to vertical mergers? And what steps do you recommend Congress, additional steps that Congress should take to support vertical merger enforcement? So it's kind of like, how can this be helpful with vertical mergers? The additional funding, which, as you know, was done by charging more on the large mergers and less on smaller mergers. How can that funding be helpful? And then what else do you think Congress should be doing?
Great. Thank you very much, Madam Chairwoman, for the question. So the agencies may be able to bring more cases as a result of receiving additional funding. There are many more mergers that need to be examined today than we have had historically, and so I think that is really testing the capacity of our antitrust enforcement agencies. The funding has not been keeping up with the increase in mergers that need to be examined. So making that change in the Merger Filing Fee Modernization Act is hugely helpful for that. I do think as a next step that they actually need even more funding, even more resources. I fear that they will still be resource constrained even after.
And is it true that these, from what I recall, they bring in funding, they bring in money for bringing these cases because of either remedies, payments, filing fees, and the like?
Right. So on mergers, I think that comes from the filing fees, but certainly other cases that the agency, that in particular, I think about the FTC is always returning a lot of money to the Treasury from prosecuting fraud and things like that. So they absolutely are bringing in money as well.
All right. Thank you. Dr. Rose, one thing that we've seen is that vertically integrated online platforms will often use their dominant position in a market, as we've discussed today, to preference their own products or content. That's why we've reintroduced the bipartisan, Senator Grassley and I, America Innovation and Choice Online Act. We thank Senator Blumenthal for being one of the many co-sponsors. Dr. Rose, how could more vigilant review of vertical mergers help to prevent companies from unfairly preferencing their own products and services over those of competitors? And we're talking here, as you know, the bill's been endorsed by the National Federation of Independent Businesses because of the fact that small businesses feel very strongly about this, that they are getting pushed down the platform in preference for things like Amazon Basic products on the Amazon platform. Professor Rose.
So I think there are two parts of your question, and the first I want to really highlight is, again, I keep coming back to, as you've heard also, I think, from others on this panel, the benefit of congressional action. And, you know, if we take something like self-preferencing, I think that's a behavior that is currently extremely difficult for U.S. antitrust enforcers to reach, even if it is reflective of anti-competitive action that you know, would fall under Section 2. It's just extraordinarily difficult to bring an enforcement action and succeed in court. So I think Congress making it clear that that's a violation will help both in deterrence and in...
Which they've done in other countries.
Yeah. Well, in other countries, what's the equivalent of our Section 2 standard is also a bit easier. You've got this abuse of a dominant position that we don't have here that allows them to enforce it. So I would just say, you know, if we've got a problem, and self-preferencing may arise in many contexts that have nothing to do with vertical acquisitions. It may just arrive organically. That having this kind of congressional action to make clear what types of behavior and conduct they feel violate the law would be very helpful. In terms of vertical mergers, you know, I guess I think, and this is something that we've seen the agencies, I think, begin to consider, that the acknowledgement that the more you're acquiring companies that are related to you in either in a vertical chain or with these platforms, it's, you know, it may not even be vertical. They're depending on you for some things, but they're complementary, part of this kind of two-sided market. I think recognizing that there's a potential harm that can arise from increasing your activity off the platform that, you know, that then is in conflict with providing service to your downstream or small business competitors, Amazon Basic competitors. You know, you have an incentive to preference your product over theirs. I think recognizing that potential in mergers could be an important thing for agencies to do. I think it's going to be extremely difficult to successfully bring challenges based on that theory of harm, but I think if Congress demonstrates...
Without additional legal authority.
Yes.
So we're just, I mean, my problem is and I'm going to turn over to Senator Blumenthal, who has done some incredible work on app stores and the like. It feels like to me that we're just static. We're pretending the world is as it was, not quite back to the Standard Oil days with the old cartoons, but 30, 40 years ago, and we have this whole new market, and we haven't really passed, with the exception of the resources and the venue bill, one piece of competition legislation in the tech area, and we're just pretending like it's not there. And the rest of the world isn't. They're moving around. Right. They're looking at it, and so I just think in the end, it's going to be at our great folly for competition and for the economy as a whole, because the power is so immense, with 90% market share for Google of search engines, and then not putting any guardrails in place is just going to lead to much more limited choice and all kinds of little companies going under, because they're just not going to be able to compete if that is their gateway.
Or we outsource our enforcement to Europe and the UK.
Well, that is exactly right. We don't have our American brand of enforcement. We are, of course, these companies who are proud of the innovations they brought in, but that doesn't mean you just step back. We were also proud that they built the railroad. That really was a great thing, but we didn't just step back and say, this is just going so well for everybody. We said, okay, we have to put some rules in place. This just isn't happening here. And that's what I'm trying to convince my colleagues of, that, as you say, we are outsourcing how this is regulated to other nations as we speak, if we don't do something ourselves. What a great segue to Senator Blumenthal. Thank you.
Definitely outsourcing enforcement to other countries, to Europe.
So I chair the Rules Committee, and we're working on a number of pieces of legislation, and I've really appreciated working with Senator Hawley on some of this. But one bill is, watermarks and making sure that the election materials say produced by AI. But I don't think that's enough when you look at the fact that someone's going to watch a fake Joe Biden or a fake Donald Trump or a fake Elizabeth Warren, all of this has really happened, and then not know who the person is and not know if it's really them. And it's not going to help just at the very end. It might for some things, but to just say at the end, oh, by the way, that was produced by AI. I hope you saw our little mark at the end that says that. So could you address that, Professor Russell, how within the clear confines of the Constitution for things like satire, we're going to have to do more than just watermarks?
I do want to be careful not to veer into, once again, the sort of Ministry of Truth idea. But I think clear labeling, I mean, if you look at what happened with credit cards, for example, it used to be that credit cards came with 14 pages of tiny, tiny print, and that allowed companies to rip off the consumer all the time. And eventually, Congress said, no, there's got to be disclosure. You've got to say, this is the interest rate, this is the grace period, this is the late fee, and a couple of other things. That has to be in big print on the front of the envelope or on the front page. There are very strict rules about how you direct market credit cards and other lending products. And that's been enormously beneficial because it actually allows competition on those primary features of the product. As opposed,
you can't really compare a credit card to someone who's telling the United States of America that there's some kind of a nuclear explosion when there isn't.
But the point being, we can mandate much clearer labeling than just a little thing in the corner at the end of the 90-second piece, right? We could say, for example, there's got to be a big red frame around the outside of the image when it's a machine-generated image.
Okay, I'm just going to, Professor Benjia, what do you think?
Well, my view on this is we should be very careful with any kind of use of AI for political purposes, political advertising, whether it's done officially through some agency that does advertising or in a more direct way.
But it might not be actual advertising. It's just put out for circulation. That's always what we've confronted because the Federal Election Commission, while deadlocking on this, has asked for authority, including the Republican-appointed members, to do more, but go ahead.
In many countries, any kind of advertising, which would include disseminating such videos, is not allowed for some period before the election to try to minimize the, the potential effect of these things.
Right. Could I just, Mr. Amode, one significant concern, just switching gears here, because I talked to some people in the banking community about this, small banks, is that they are really worried they're going to see AI used to scam people, pretending to be your mom's voice or your more likely granddaughter's voice, actually getting that voice right, making a call for money. How can Congress ensure that companies that create AI platforms can not be used for those deceptive platforms? What kind of rules should we put in place so that doesn't happen?
Yes, Senator. So I think these questions about deception and scams are probably closely related to these questions about misinformation, right? They're a little bit two sides of the same coin. So I think on the misinformation, I wanted to kind of clarify, there's technical measures and there's policy measures. Watermarking is a technical measure. Watermarking makes it possible to take the output of an AI system, run it through some automated process that will then return an answer that it was generated by AI or not generated by AI. That's important, and we're working on that, and others are working on that. But I think we also need policy measures. So going back to what the other two witnesses said, focusing on, a requirement to label AI systems is not the same as a requirement to watermark them. One is for the designer of the AI system to embed something. The other is for wherever the AI system ends up, in the end, for someone to be required to label it. So I think we need both, and probably, this Congress can do more on the second thing, and the companies and researchers can do more on the first thing.
Okay, and so what are you talking about, the scams where the granddaughter calls in, the grandma goes out and takes all her money out? We're just going to let that happen, or?
Well, certainly, certainly it's already illegal to do that. I can think of a number of authorities that we could use to strengthen that for AI in particular. I think that's kind of up to the Senate and the Congress to figure out what the best measure is. But certainly I'd be in favor of strengthened protections there.
Well, I hope so. About half of the states have laws that give individuals control over the use of their name, image, and voice, but in the other half of the country, someone who was harmed by a fake recording purporting to be them has little recourse. Senator Coons and Tillis just did a hearing on this. Would you support a federal law, Mr. Bengio, that gives individuals control over the use of their name, image, and voice?
Certainly, but I would go further. If you think about counterfeiting money, the criminal penalties are very high, and that deters a lot of people. And when it comes to counterfeiting humans, it should be at least at the same level.
Okay. One last thing I wanted to ask about here is just the ability of researchers to be able to figure out what is going on. And there's a bill that a number of us are supporting, including Senator Blumenthal, that allows for researchers the transparency that we need, and including Senator Cassidy, Cornyn, Coons, and Romney. It's called the Platform Accountability and Transparency Act, to require social media companies to share data with researchers so we can try to figure out what's happening with the algorithms and the like. Dr. Russell, why is researcher access to social media platform data so important for regulating AI?
So our experience actually involved 3 years of negotiating an agreement with one of the large platforms, only to be told at the end that actually they didn't want to pursue this collaborative agreement after all.
We don't really have 3 years to spare on AI, it sounds like. So
no, we don't.
Continue. Yes.
And I then discussed this with the director of the digital division of OECD, and he said I was about the 10th person who had told him the same story. So it seems there's a modus operandi of appearing to be open to collaborations with researchers only to terminate that collaboration right before it actually begins. There have been claims that they have provided open data sets to researchers to allow this type of research, but I've talked to those researchers, and it hasn't happened. It's
And why is it so important to
extraordinarily
have it to put in place these regulations? We know we can't wait for you to get all the data, obviously, and we can't let it take 3 years. But putting in place clear mandates that data be shared, why is that helpful?
Because the effects of, for example, the social media recommender systems are correlated across hundreds of millions of people. So those systems can shift public opinion in ways that are not even necessarily deliberate. They're probably not deliberate, but they can be massive and polarizing. Unless we have access to the data, which the companies internally certainly do, and I think the Facebook revelations from a few years ago suggested that they are totally aware of what's happening, but that information is not available to governments and researchers. And I think, in a democracy, we have a right to know if our democracy is being subverted by an algorithm. And that seems absolutely crucial.
All right. You want to add one more thing?
Yes. Trying to respond to your question from another angle, why researchers? I would say academic researchers, not all of them, but many of them don't have any commercial ties. They have a reputation to keep in order to continue their career. So they're not perfect, but I think it's a very good yardstick to judge that something.
Except for Professor Russell. Okay, very good. Do you agree with it too then?
Yes, I just wanted to say I think transparency is important even as a broader issue. A number of our research efforts go into looking inside to see what happens inside AI systems, why they make the decisions that they make.
Okay.
Yeah,
I've got to turn over to my colleagues who've been patiently waiting. Thank you.
Thank you. We'll circle back to the black box algorithms, which is a major topic of interest.
I'm just going to ask you each 2 sets of questions because I know my colleagues have questions to ask. Mr. Federico, for much of your career, you were tasked, as Senator Graham pointed out, with being a zealous advocate for the interests of your clients as an attorney in the Navy as well as a public defender. You have represented clients who've been accused of serious crimes. You've also prosecuted cases and served as a military judge presiding in over nearly a dozen cases. Can you say more about how your view about the role of a judge and how it differs from that of an advocate? And do you have any reservations about setting your personal views to the side when evaluating the facts or the laws as a judge? And talk a little bit about that difference of your past work, because you've been on, you get all the sides, and how you've been able to do that as a magistrate judge.
Thank you, Senator. I'll answer the second question first. I have absolutely no reservations or hesitations about setting aside my role as an advocate if and when I'm confirmed as a circuit judge. In fact, I've, as you noted, had that experience as a military judge. And so an advocate's job is to represent the interests of a client as zealously as you can within the bounds of the law. I have, of course, departed from that role as an advocate as a military judge, put on the robe, and assumed the bench. And just as, if confirmed, I would have no hesitation to become a neutral arbiter of the issues and disputes before me. I've done that as a military judge, and I could do it again as a circuit judge.
Very good, thank you. Mr. Kohler, congratulations, Judge. I think we in Minnesota, we've had 2 magistrate judges since my tenure on this committee that have become federal judges. I think it's great experience. For one thing, you know the judges, and that helps. And you were appointed by the sitting district court judges and have presided over things like civil motions, criminal proceedings, settlement conferences. How has your experience as a magistrate judge informed your views of what you'll be like as a federal judge?
Senator, it's been an incredible honor to serve as a magistrate judge. As you indicated, it's an honor to serve the court and the judges of the court. And more specifically, I think it's prepared me very well for the role of circuit judge. I have cases that I have on consent where I've tried jury trials or decided other dispositive issues. I understand the civil docket and everything that goes into it in the discovery process. Obviously, I have vast experience in the criminal area as well. And that has allowed me to see cases from beginning to end and understand what the record is when you're then reading it kind of cold, if you will, from an appellate standpoint after having done appellate work as an assistant United States attorney. So it's prepared me well to understand the range of issues that come before federal courts and how that record is made and practical things to consider on appeal.
Thank you very much.
Senator Kennedy.
Thank you, Mr. Chairman.
Senator Klobuchar.
Thank you very much. I'm going to focus on our Minnesota nominee, but thank you to the other nominees as well. Judge Bryant, prior to your decade of service on the bench, you served as an assistant U.S. attorney in Minnesota, where you prosecuted over 350 defendants. Law enforcement officers that you worked with said you will make, in their words, an outstanding federal judge. As case agents, they wrote that we knew that he treated every case as his highest priority. We believe that he will do the same for each of the matters assigned to him as a federal judge. What motivated you to become a federal prosecutor? What cases are you most proud of? And then what lessons did you take from that time that will help you as a judge, or help you as a judge?
So I think you look to the example of both of my parents, my father was a clinical psychologist after leaving the Army and dedicated his professional life to helping people. My mother was a public school teacher throughout her life, 35 years plus of being a public school teacher. And they instilled that appreciation for public service in me, and I think that's one of the reasons I was driven to pursue that career. As a prosecutor, I respected the case agents that I worked with very much, and the sacrifices that they made, the risks that they had to take to do their job, and I felt it was only fitting that the U.S. attorneys who were working with them, the assistant U.S. attorneys working with them, would also bring the same sense of dedication that they showed. I think there are a lot of lessons that I can take from my time as a prosecutor that will help me as a judge if confirmed. I take those lessons with me to the bench every day, the lessons I learned from the judges in front of whom I practiced, and I hope to be able to emulate all of their great examples when I take the bench.
Thank you. If you are confirmed, you'll be the first Latino on the federal bench in Minnesota. You've been active in Minnesota Hispanic Bar Association, specifically working with young attorneys. Why do you believe that mentoring young attorneys is so important?
Well, because I've experienced the benefits of being mentored myself. I know that as a young attorney, there's a lot of questions that you come to the office with, and it does really help to have someone supportive who can take you under their wing. There's a letter from one of those persons, Erica McDonald, who was someone who I was mentored by as a young AUSA and was honored to have her support as part of this process. But that's why, because I know personally how meaningful it was for me.
Yeah, I'll note that Erica McDonald was a line prosecutor at the U.S. Attorney's Office, went on to be a state court judge, I believe, and then was the U.S. attorney appointed by the previous administration. So, Judge Bryan, you presided over 8,500 cases as a trial and appellate judge. You've been reversed only 6 times, 4 times on the district court and twice on the Court of Appeals. I'm sure you remember each of them. But nevertheless, your rulings have been upheld 99% of the time. Could you talk about your judicial decision-making and what led you to have that kind of a record?
Well, I, as a judge, have tried to faithfully and objectively apply binding precedent to the issues in front of me, try to understand and frame the issues in a concrete way, but one that allows for application of binding precedent. The The few times where I have been reviewed, I welcome it. It's an important, a crucial part of what makes our system of justice consistent and fair. So I'm great. I learn from it every time, and I welcome it whenever it occurs.
Thank you very much. I don't have any other questions.
Thanks, Senator Klobuchar. Senator Kennedy.
Thank you, Senator.
Thank you.
Thank you.
Senator Klobuchar.
Thank you, Chairman. Director, last year we talked about my bipartisan bill that Senator Cornyn and I put forward to ensure that women in custody receive access to the prenatal and postpartum care that they need. The bill would establish care standards for how federal facilities treat pregnant and postpartum women in custody while ensuring they have access to critical health care and nutritional services. Did you have a chance to look at that, and do you agree that we should ensure that pregnant women in custody receive health care? Could you just give me a status report on what's happening there?
I can, Senator. So yes, I did read the bill following the last hearing and read it again in prep for this one, so thank you. In February of 2022, the Federal Bureau of Prisons issued the Management of Pregnant and Postpartum Offenders with technical guidance in there that I think speaks parallel to your bill. Some of the things I'll just mention is we are careful not to restrain pregnant or postpartum women. Women have the opportunity to bond with their children. We offer them what we call the MINT program, the Mothers and Infants Together program, at 5 community-based facilities. In the event that the women can't leave the Federal Bureau of Prisons and bond with their child in that community setting, we do have an intergovernment agreement with the state of Washington, who does have a residential parenting program. And then we also offer women who remain in the institution an opportunity to engage in prenatal and postpartum parenting programming to assist them in raising those children from inside.
Okay. I know one of the things in the bill is requiring BOP to transfer inmates experiencing high-risk pregnancies to a facility that can provide them adequate care. Is that part of the standards that you have?
It is, Senator. Yes, we have a facility specifically for women who are at high risk.
Okay. I have heard from constituents about staffing shortages and I'm sure you've seen this around the country, various other industries and entities are as well, but specifically at Bureau of Prison Facilities in Minnesota. These reports have been corroborated by an OIG report released this May that found significant staffing shortages at the Federal Correctional Institute in Waseca, Minnesota. These staffing shortages have resulted in officers working large amounts of overtime and non-correctional officer employees, including cooks and teachers and nurses, being forced to fill in under that process, I believe, called augmentation. And, you know, I'm a big believer in doing a lot more on workforce outside of the prisons, and it's everything from workforce training to doing more on work permits and immigration reform. But could you talk about what steps you are doing to ensure that augmentation is used appropriately?
Thank you. So, you know, our employees, and many of them are in the room, could speak to this. We're exhausted before the pandemic, and then the labor market got worse, and views of law enforcement changed, and so recruitment and retention has been an issue. It's been a top priority of ours. We consulted with 2 external organizations to help us understand our staffing issue and change how we market and brand ourselves to bring additional people in. We've seen improvement. We had a 60% increase in those that applied to the organization in the last year and a 20% decrease in separations. So we are not where we need to be to end augmentation and overtime, but we are making progress.
What steps can Congress take to help states that want to address the issue of understaffing at BOP facilities?
You know, I believe that there are two categories. One, help us sell who we are and what we're about, and that the Federal Bureau of Prisons is an amazing place to work, because I believe it is. There are heroes behind me who do amazing work every single day. And any help with the labor market. I mean, that is, as you mentioned, everyone is struggling right now. And it's just compounded in law enforcement and correction.
Yeah, I actually visited this facility once that I referred to, and I left with that feeling in terms of the work the employees were doing, but also the inmates, the skills they were learning, and just the energy in terms of what they could do with those skills when they got out, which we have to be thinking about as well in terms of our workforce. That obviously, with exception of very violent offenders and people who are in for life, as they should be, there are a number of people that are going to get out that are in there for different kinds of offenses that we want to make sure are learning these skills. One last question. What is the Bureau of Prisons doing to mitigate the negative effects that some of this understaffing has on the mental health of BOP employees?
Yeah, these are very complex and difficult jobs, and then when you're engaged in overtime and augmentation, that mental health and that physical struggle gets even greater. So in the last year, we've changed and modified some of our employee wellness policies to increase resources to our employees, to ensure that our crisis teams have more availability and access to our employees and assist them following an incident. We've also changed our practice so that retirees can access these resources, and that's just the beginning. We will continue to work on employee wellness, both physical and mental health.
Thank you.
Thank you, Senator.
Senator Blackburn.
Thank you, Mr. Chairman, and Director, thank you so much for being here with us today. I do appreciate
Very much. I want to thank you, Senator Blumenthal, and you, Senator Booker, for your work, and I'm looking forward to working with you on both my positions on Judiciary and Commerce to get this done. I will try to show the same restraint as you did, Senator Booker. It's not as good, but it's pretty good. In asking my first question to Governor Baker and noting that, given that he's from Massachusetts, where they play a lot of hockey, that the University of Minnesota, Duluth, and U of M women's hockey teams have collectively won 11 NCAA championships since 2001. I'm not sure you can have that record in Massachusetts.
I
Is that
got
correct?
nothing there. I got
Okay,
nothing.
all right.
Harvard has won several women's NCAA championships, but those numbers in Minnesota are very special.
Excellent, excellent answer. Okay, next. Can you elaborate on how the NCAA's new policies will help student athletes, the ones that you note in your written testimony about improving financial outcomes, including in areas of financial literacy, standard contract terms, agent registration?
Sure. The policies that the D1 Council is working their way through should be voted on before the end of the year. But they're basically designed to create what I would describe as some transparency and accountability. The financial literacy piece is something some schools already do. We would like to see everybody required to do that. The Uniform Standard Contract is basically about doing exactly the same thing we do in almost every financial transaction industry in America, which is to have a contract that represents basic terms. And if an agent wants to move off of that, they need to explain to the student athlete and the family why they want to move off it. The third part is to create what I would describe as a system where student athletes would make available to their schools what their deal looks like, and then all that data would get de-identified and incorporated into kind of a public distribution, so that if you were a gymnast, if you were a football player, if you were a basketball player, you would have some idea of what traditionally NIL looks like for you or for somebody like you, so that you have some idea about what it is you should get. And then the final piece is to make sure that we have an agents registry where agents have to, among other things, say they work for their customer, their client, because there's way too many examples at this point of agents taking advantage of
I
student
remember
athletes.
we talked about that when we met. Thank you. Mr. Petiti, how do the lack of uniform rules, I think we have 31 state laws now that have emerged, how do that lack of rules put schools and states without NIL laws like Minnesota at a disadvantage because they cannot take advantage of state laws that preempt NCAA rules and are more permissive?
It's creating a recruiting and a transfer advantage in those states where money can flow to student athletes that is encouraging attendance, it's encouraging transfer. States that have not acted so far are in different positions. What we have, it's been mentioned earlier, is a situation where we compete in one conference across many states. We want that to be somewhat balanced. There's already enough. We have different size stadiums. There's a lot of things that impact competitiveness. But in this case, we're seeing states increasingly keep ratcheting up what they're doing to try to improve competitive. So it starts at one place, and the next state keeps going in one direction.
And Ms. Thomas, does that lack of a single nationwide standard make things more difficult for student athletes?
Yes, it makes things much more difficult and very confusing a lot of times.
Okay. Another issue that's related, Ms. Bodensteiner, after 50 years of Title IX, our athletes shouldn't have to fight to get adequate pay. As you know, Senator Cantwell and the Commerce Committee, we've worked to pass legislation, the Equal Pay for Team USA Act, which now requires equal pay and resources. How can we ensure that gender pay disparities don't persist under an NIL system?
I think it's a combination of what Governor Baker and Mr. Swarbrick have already mentioned. One is transparency, and two is getting back to legitimate NIL deals where the actual capitalist market is paying, in which case women will succeed at a greater level, I believe, than male athletes. But I think it all comes down to getting rid of this, should be impermissible market of paying athletes to attend institutions.
Okay, Mr. Petiti, back to you. When we had a hearing, we all saw firsthand Simone Biles, Allie Raisman, Michaela Maroney, and Minnesotan Maggie Nicholas testify before the Senate Judiciary Committee in 2021. By coming forward, we know they made a difference. What measures are the Big Ten and its member institutions implementing to ensure these types of abuse don't occur? We're very proud to have the final Olympic gymnastics trials destined for Minnesota in June of 2024, and I think there'll be a lot of discussion about that. So if you could just answer it from the Big Ten's perspective.
Yes, thank you, Senator. First, we want to make sure we ensure the safest environment for student athletes, for coaches, and for the students that work in athletic departments. That's number one. Since then, we were the first to install a chief medical officer. The amount of attention and resources from the conference office, what we're trying to do is make sure that our members have, the best resources to make sure that that we've guaranteeing a safe environment for everybody involved.
Thank you. And I'll ask on the record, Mr. Huma, questions I had about the announcement on the long-term health and disability benefits, which I'd like to, I'll do it later and defer to my colleagues. Thank you.
That. And thank you for being here today. Thank you.
Senator Klobuchar.
Thank you very much, Mr. Chair. I'll start with you, Ms. Argentini. First of all, thanks for your work. I think you know how important it is for me to make sure the antitrust division is funded, both for civil and criminal cases. Senator Grassley and I led the Merger Filing Fee Modernization Act, which passed the Senate and is starting to be implemented, and I hope it's implemented correctly. I'll leave that for another day. But could you talk about how important it is to make sure we have funding in antitrust, one, and then secondly, a more kind of in the weeds question. When the Antitrust Division recently announced deferred prosecution agreements with 2 pharmaceutical companies, the department determined that a fine was not sufficient penalty and instead required the drug companies to divest from a widely used cholesterol medicine that was a core part of the price-fixing scheme between the companies. This was the first time that the department required divestiture as part of a corporate criminal settlement. I'm not complaining about it. I know there's a lot of people complaining about things here. I just wondered if you could talk about innovative remedies such as divestiture to promote accountability and deter further corporate crimes, because I see it as a way of helping us on the price issue.
So thank you for your question. So the Department of Justice, including the Antitrust Division, are committed to enforcing all federal laws, especially to maintain the competitive environment that is so important to our economy. And so I think when you're talking about innovative remedies and divestiture, I would defer to the Antitrust Division on that specific remedy to discuss it. We in the Criminal Division have also tried to use innovative solutions in our corporate resolutions to make sure that we are changing a company's corporate culture. One example that I could point to is an historic Binance resolution, which we announced last month. Part of the resolution with the company required the CEO to step down and for them not to have any additional CEOs that had been convicted of crimes. It's a way to change the company from the top, from the tone at the top. But we are always looking for new ways to incentivize good corporate conduct across the department.
Okay, thank you. Mr. Olson, in October, Deputy Attorney General Monaco said that the biggest shift in corporate criminal enforcement is the rapid expansion of national security-related corporate crimes. The National Security Division has added more than 25 new prosecutors to meet threats from corporate crimes, from terrorist financing to sanctions evasion schemes that fund North Korea's illicit WMD programs. Can you talk about that and also that one of the most effective ways of shutting down a criminal organization is by targeting their income, as you know. The U.S. and its allies have developed a robust sanctions scheme against the regime, against the Russian government and the oligarchs who support Putin. Talk about how that's going. So really two questions. One is the importance of this expansion to focus worldwide on terrorist schemes, and then the work on Russia.
Yes, of course. Thank you, Senator. As the threat landscape has changed, as we're seeing increasing threats from nation states like Russia, China, Iran, North Korea, our enforcement priorities have changed. So we are increasingly focused on, as you mentioned, sanctions, evasion, violations of export control, nation-state cyber attacks, foreign malign influence. And these enforcement priorities mean that we are increasingly interacting with the private sector, because they are often on the front lines of these violations. In some cases, actually as the violators, and we've brought cases against companies like British American Tobacco that evaded our sanctions against North Korea. And so what we've done is invested in those priorities by, as you mentioned, adding prosecutors to our counter-espionage, excuse me, and export control section. We've added 2 experienced prosecutors to help lead this effort. But we are responding to the threats we face, and what that means is increasing efforts around these crimes that occur at the intersection of national security and the decisions that companies are making. I should add that in addition to our straight enforcement, our prosecution efforts, we also are trying to drive compliance. I think it's really important to identify the fact that companies are on the front lines and they're sometimes the first to see these violations. So they need to develop these compliance programs. Let me turn to Russia, to your second part of your question. Of course, Russia and its invasion of Ukraine is a priority for us. I was in Ukraine last month. I met with officials there. They are very determined to support our efforts to hold Russia accountable, whether that's going after oligarchs who support the Kremlin or stopping the flow of technologies that go into Russian military systems. So that's been an effective effort. We have more work to do, but we're very focused on that.
Thank you.
Thank you, Senator Klobuchar. Senator Tillis.
Thank you, Mr. Chairman, and thank you both for being here. Ms. Argentieri, I got a quick question. I think you mentioned or you said that advisory report.
Thank you, Mr. Chairman. I just keep thinking about all of us having gone to schools or served on committees or doing things that are not, when we're not the decision makers about things, and if we were all held responsible for that, I don't think any of us would be up here. So I want to start with you, Mr. Manji. Could you talk about your years of experience, your trailblazing nomination we know about? Can you talk a little bit, I see your proud family behind you, of your family's history and how that has influenced your view of the rule of law?
Thank you, Senator. Senator, I grew up in Pakistan, and that is a country, the people of whom I love dearly. It's part of my heritage, it's part of my history. But a big part of my experience growing up was seeing that in that country, if your rights are violated, there is often no recourse. There is no remedy, and the legal system will not come to your aid. Indeed, the legal system will often be the one that's oppressing you in the first place, particularly if you're a woman or a minority. And that experience impressed upon me so deeply the value of being in a country and in a place where if your rights have been trampled upon, like in the case of the Islamic Society of Basking Ridge I mentioned earlier, you can go to the courts and you can get recourse. And for me, that is what the conception of justice is all about. And let me add, Senator, responding to your predicate, I have a history of 23 years now in this country as a lawyer working on various causes that are important to me. And I'm ready to...
In the private sector, correct? For many
Yes, yes, Senator. And I'm happy to answer for any decision I've made, any statement I have made. But it has to be something that I've done.
Okay, very good. Thank you. And we do appreciate, I'm sure you've heard, the mosque in Minnesota that got bombed. FBI actually investigated, found the guy that did it. So appreciate your work on that front, as does our Muslim community. Ms. Berner, one thing we haven't talked much about is your work on domestic violence. And the committee received a letter of support for your nomination from the National Task Force to End Sexual and Domestic Violence, which praised your background and experience with issues of domestic violence and sexual assault. Former prosecutor, we worked on a lot of these cases, had a domestic violence service center in my office that was very well known nationally. Can you talk more about your work to protect victims of domestic violence and sexual assault?
Good morning, Senator, and thank you for your question. Before I went to law school, I was the director of a national organization in Israel to fight domestic violence and sexual assault of women. And it was in that capacity that I first came to meet attorneys. I had had no lawyers in my family, and I had not previously known any attorneys. And I saw the power that the law can bring to protect those who are not always able to protect themselves, to advocate on behalf of women and families and children. And I was inspired by that work to apply to law school and to become a lawyer.
Okay, very good. And I know the committee received a letter of support for your nomination from the International Brotherhood of Police Officers. They praised your work on behalf of law enforcement, as well as your excellent legal talent, deep listening skills, and collaborative and fair approach. Can you talk about the work that you've done in law enforcement outside of domestic violence?
Yes, Senator, I have been proud to represent tens of thousands of police officers and correctional officers from around the United States. I have deep respect for their role in our society, their courage, and their commitment to protect communities. And it has been my honor to protect those members of SEIU and to work closely with union members from every industry in our country. And I am humbled by the support from different unions that have come to support my nomination, including police unions and firefighters and other unions that have come to support my nomination. It has been truly humbling.
Thank you very much.